And
so, Stephen, did you mean 2.2 and 2.23, or do you want him to have his finger in sort of two pages?
two different places, 2.2 and put 2.33 on page 13.
Okay.
And Stovolds Hill has got a name, is a hill, which is that, and you're talking about a slope, and behind the appeal site, the caravans to the south of it are higher than the appeal site.
Sorry.
The land goes up, the road goes up Stovolds
Correct,
Hill.
yes.
It's a hill.
Sorry, I just was puzzled by which direction we were going.
Okay, all right. And then the next point that I was going to take you to was the decision letter of Inspector Gilbert. And I don't know if you've got that handy.
I have.
Paragraph 12, the last sentence. She talks about the proposal and Lydia Park would inevitably be viewed together. Do you see that?
Yes.
And
Strictly speaking, would inevitably be viewed together.
Yeah.
From the adjacent track or road. Yeah.
That's right. And if we look at your CW5, please.
Yes.
We see the aerial views showing a number of caravans. First of all, image 1, open brackets, 2, close brackets, looking east. Do you have that?
Yes.
And then if you scroll down to the bottom of CW5, please.
To image 5.
That's right.
Yeah.
One of the issues between the parties that came up in the landscaping, it's a critical issue for the inspector to decide, is whether he looks at the landscape character, particular designation. We're in the low wooded wheeled designation, yes. or whether you look at the area in the context of Lydia Park.
Yes.
And I'm putting to you that the photograph at image 5, it's not a public view, is it? It's just a drone.
They're certainly in that appendix, they're all drone images.
And
so
it's distorted and artificial just to be considering the site as developing that field when the picture deliberately doesn't show the wider context of the caravans.
I'm just trying to understand image 5. It says Dunsville Road runs from the lower left to the centre. From that, Mr. Wood, do I take it that the Lydia Park's off to the right?
If I can explain, if you have regard to image 4 and image 5, yeah. Image 5 is sort of the top slice, top left-hand slice through image 4. And if you look at that top left-hand side, you'll see kind of 2 mounds in a paler coloured field. And those are the 2 mounds almost in the foreground of image 5. But I don't know how drone cameras work, but I would say image 5 is a telephoto view that just misses all the developments at Lydia Park.
But if I was a newcomer and had just walked into the room this afternoon, and I said, or I asked, what's the sort of location of the appeal site, and you showed me that photograph, it would be a completely artificial and contrived view when you know what's to the right.
Well, in terms of the intent of the photo is simply to show the relationship between one set of sites and another site. I'm not relying on these photos in terms of landscape, impact, character, visual views or anything else like that. That's handled by Mr. Dudley, who provides all his own evidence in terms of character, etc.
Yeah, and context is everything, isn't it? And the inspector is not going to close his mind to the presence of the appeal site adjoining Lydia Park?
No,
Inspector, I can short circuit that. I don't want to interrupt my little friend, but we expressly ask you to take it into account in Mr. Dudley's evidence as a receptor. So we would agree and say that that's the approach you should take if that can short circuit things.
Well, it was something that my Mr. Woods was being cross-examined on, and it's the context of Lydia Park when you're assessing the landscape harm. Just distracted me slightly, that intervention. Coming back to the point of looking at image 5, we know about the AGLV.
yes.
My question to you is, if the purpose of the AGLV was to reserve a buffer zone around the fringe of the national landscape, not knowing whether the boundary of the national landscape would be extended, and now that exercise is being carried out and we know that it's not being extended, then the purpose of the AGLV policy to pending that decision is defunct, it's spent.
That wasn't the only purpose of the AGLV. So the other purpose would still remain. I'll
this is
turn the
19
policy up to look at it. But it is being, one of its purposes was to provide a buffer to the AGLV. So for its other purposes, it's not debunked, and
Right.
that is something which will
Okay.
need to be reviewed potentially
All right.
when the next local plan rolls forward.
So I think it's a designation that dates from the 1970s, isn't it?
So
The AGLV, that local designation.
it certainly goes back many years.
Yes.
Mr.
Yeah, that's
Dudley
right.
gives you the
That's
details,
right.
yes.
But the purpose that I was asking you about, you were agreed it was defunct. I'm going to move on from that question.
Okay.
He didn't
No.
agree it was defunct. He said that it wasn't defunct for the other purposes, but in respect of the element for the national landscape, that was something that was upcoming, but he didn't agree it was defunct.
I put it to you, Mr. Ward, that the purpose of the AGLV was to safeguard land where the national landscape might be extended into, and that purpose has been spent because we now know it's not being extended into that area.
Take your clarity, let's look at the policy. And I will read through quickly, but the same principle for protecting the AONB national landscape will apply to the AGLV, which will be retained for its own sake and as a buffer to the AONB until there's a review of the Surrey Hills national landscape boundary.
Right. Well, that is exactly my point. I'll go on submissions on that. We don't apply national landscape policies to the location of the appeal site, do we? It's just countryside, and it's governed by HN4.
Well, we apply national landscape policies to the extent that the national landscape policies has regard to the setting of the national landscape and the site is in with its setting. But no, we don't treat the site as within the national landscape.
Well, I don't want to go back over the
No.
countryside evidence, landscape character evidence, but if the inspector was to go further up Hascombe Hill, what would he see? He'd see the aerodrome very clearly behind Lydia Park. He'd see a massive caravans of Lydia Park, and he'd really, really struggle to distinguish the appeal site from Lydia Park.
I disagree. Mr. Dudley has given his evidence, and clearly he is the council's main witness on that. From my own experience, I've walked most of the footpaths around Hascombe Hill. It doesn't immediately strike you, but if you stand there, you can identify the sites. That's not from, well, not this time of year. From the top of Hascombe Hill, you do get, well, when I was there, fleeting views as the branches move on trees, etc.
Because
But
the
to the
path
extent that
behind,
you're fleeting through the trees, it's difficult to distinguish anything.
exactly, the path behind the trees.
But certainly from halfway up Hascombe Hill, I've forgotten which footpath it is, but the one that goes across almost meadowland, etc., just below the woodland, you do get fairly clear views.
We've got an X on a map inviting a
Yes.
suggested point for the inspector to view from there. And he should be considering, not as it is now, but as it would be once it's conditioned with the landscaping having taken effect.
Certainly he will need to consider whatever the landscaping proposals are.
I'll move on. In relation to paragraph 3.4 and DM 37, 3.4 of your proof, you refer to day rooms, and DM 37 referred to the size of a plot. And one of the points that you raised this morning made me think, and I took instructions on it, because you were saying that some shared family facilities don't need a day room for each plot. And in fact, this inspector, and I've got instructions to say this on behalf of the appellant B, he needn't allow 3 day rooms if he wanted to reduce the impact. They've got to have a day room for Huey. But actually, because they're a family, if it was the difference in between getting permission, this inspector could actually condition it so that there's only 1 day room instead of 3 rooms.
Only for the sake of precision, and I haven't got a note of what I actually said. My understanding, I didn't comment on whether there was a need for shared day or a need for shared day rooms, but certainly said in my experience, some of the permissions that have been granted at Lydia Park do have shared day rooms. So I presume that is something that is acceptable. And yes, okay, I note your comments now. I know, is it Martin or Huey? The proposal for that pitch is for a larger than normal day room to meet, I'm going to call it physio requirements, basically.
But that could also function in terms of cooking and showering facilities for the sons' families.
I would presume so.
If I could turn your attention now, please, to paragraph 4.5 at page 19 of your proof.
Yes.
And the point that I wanted to make is that when Inspector Gilbert, in her decision from a hearing in August 2022, and she was talking about Lydia Park and the caravans there, would she have been aware of all of those on table 2, or are some of those subsequent to that decision? Or is there only one of them that I can see as 2023, which is the penultimate row? So all but one.
The quick or best answer I can do without wasting a lot of time on it is the only one she certainly wouldn't have seen is the 2023 one.
Yeah.
Whether she would have been aware of some of the ones in 2021 would depend on the decision dates of those applications, which could, given the time it generally takes, could well have not been until 2022. But there will be some permissions, or at least one permission there, which postdates Gilbert, and there have been numerous decisions since.
Well, that was
at least a handful of decisions since.
That was my next question, because I would like you, and I don't want to get there during the process of cross-examination because it would take us quite a while to count them all up. But I do know that there have been subsequent decisions. And the question is, it says there planning permissions for 48 pitches. And I would like to know planning permission for how many pitches as of today's date. Is it an extra 30? I don't expect you to come up with a precise figure at the moment, but as a ballpark figure, I see there's some nods at the back of the room, but I'll just leave it with you, sir, if the witness could possibly provide that figure before the end of the inquiry.
What period are you looking for, Mr. Cotter? As an update to table 2?
Yeah, in terms of you looking at a material consideration in this case, which is a previous inspector's decision letter.
Yes.
One of the material differences is that her appraisal was on the basis of a block of land to the south of that appeal site, which isn't so populated as it is now. because there's many more planning permissions that have been granted since.
So you want the number of extra permissions?
That's right, yes.
One thing I was going to ask for, Mr. Ward, and I'm reluctant to put you to more work on this. You may already have this figure somewhere, in which case it's just a question of pointing me to it. And again, I don't want to take up time now, but what I'm interested in is the total number of pictures that either had permission, or there are some pictures, I understand what I've read, that are of long standing, yet I think the council accepts don't have permission, but doesn't dispute on the southern part. That's my reading of the evidence. But
The best,
I know there are some that are disputed, that the council argues there's too many on, or they're not laid out in accordance with the planning permission. I'd like to know the total number of pictures that are accepted by the council at Lydia Park, either because they've got permission, or the council isn't intending to pursue any action against them.
So
in terms of
inspector
just
wants the
quickly then
total one.
where some of that information is, but I will need to check with council officers to see
Yes,
if there's
that's
anything
right.
missing.
Understood.
I provided in January this year, so much more up to date, but still
Yeah.
5 months ago, in Appendix 16B, and at the back of that, Table 6, which lists all the permissions up to January this year. And that does include, they're in site order rather than
And
date
total
order.
number?
So the total, well, the
16.
total number there is 54 pitches.
54.
But I don't think that would include what I've just mentioned, the historic ones.
That doesn't include the historic
I'm
ones.
interested in the total picture.
Okay.
I think the parish councils are putting it 197 plus 40 odd.
Well, I want to see what the council
So
says.
that's right, yeah.
Okay.
Yeah, the parish council may not have access to the same information.
Now, coming back to the,
But just for clarity, that site actually permitted pitches rather than numbers of caravans that are there.
My interest is in pictures, because the proposal is for pictures.
I was interested in the permitted number of caravans because it's landscape. But the inspector's looking at need and different matters. I'm looking at through the perspective of impact on character, landscape, and I'm also bearing in mind over domination on this.
I don't mean to sideshoot the question, but the big difference between those two questions is there were, last time I was advised, an awful lot of caravans which are there unlawfully.
Yes.
And
Well,
being used as
I'm-
what are referred to as the rentals.
Yep.
And the council is slowly taking action to get rid of those. So,
Mm.
but that does significantly increase the
Two-
number of caravans you will see.
Three supplementary questions on this. First of all, should the landscape character assessment carried out by the inspector take into account that the authority's current thinking is that pitches should be allocated at Lydia Park? Does that alter the context to the appeal sites, or is there no resolution? It's too tentative to even say that the council are thinking of allocating pitches at Lydia Park, because I think Mr. Jarman's got strong views on this. From your point of view, is it relevant
From
to a
my point of view,
landscape character assessment that the appeal site is next to land which the authority currently thinks would be a good idea to allocate?
Sorry, I hadn't realised the question had finished. Certainly from my point of view, the inspector needs to, or should take into consideration the details which are in the PDA, which concludes how or shows where additional pitches may be accommodated at Lydia Park. So to the extent of that they are all south of the access track.
It is relevant, isn't it?
Yes.
That the appeal sites are next to land that the council are proposing to allocate.
Well, referring to in the PDA, yes.
So you're qualifying
It's
it.
presuming the process of the next
That's
local
right,
plan,
because-
whether they become allocated or
Because
not.
there isn't any resolution. And so therefore there isn't any robust evidence, because it's too tentative. It might be consulted out and disagreed with the proposal to put extra pitches.
I'd reject the last comment simply because of examples like the appeals, the site we discussed this morning, which Mr. Woods had put in, where the council is granting permission for infill pitches within there. So I think that and there's some, at least one other one shown in my updated evidence, where additional pitches which didn't, or additional strips of land that never had a permission have now been given a permission.
What weight would you like me to attach to the very tentative suggestion by Mr. Jarman that hasn't been adopted by the council yet, that pitches at Lydia Park should be allocated? Should we attach very limited weight because it's emerging policy, or do we attach moderate weight to it? I mean, it's such an early stage, that suggestion, isn't it? We can't attach any weight to the suggestion that there will be
No,
further.
I would certainly give limited weight and potentially moderate weight to it on the basis that it's evidence the council is putting within the context of its GTA as to how it's going to meet its requirement for pitches.
But I could submit, or I will submit, that no weight can be attached to that because we don't know what the council's position is because they haven't adopted a position yet.
That is something for next week, Inspector.
Fine. Moving on from that, which is the more critical question. Why, if you think the additional caravans and this appeal site can be refused for the reason for refusal of domination, is the council proposing any extra caravans at Lydia Park at all? How can you do both?
Well, for the very simple reason, as explained earlier to Mr. Masters, if not in chief, that on the basis of the Gilbert decision, permission is being granted for sites on infill, because on the view that that will not have such an impact because it remains on the land that is not a spatial extension of Lydia Park.
So you disagree with the parish council, it's about numbers? It's not about numbers, is it?
No, to the same reason that Inspector Gilbert suggests it was not just about numbers. Yes, I disagree. Sorry, I can't remember that comment from the parish council. If it's what they said, then I disagree with it.
Now, one other point on construction of policy,
I hesitate to interrupt, but you remember paragraph 22 of Gilbert's decision made the point that there were two reasons. It was numbers and I know, but
one of the points that came up in cross-examination where I interrupted, evidence in chief interrupted on an issue of policy, is to do with a decision called R versus Protect Dunsfold Limited and the Secretary of State, which was concerning a fracking site at Loxley, which is quite close to the appeal site.
Yes.
If this area is capable of accommodating a fracking site, solar panel farm, a craft brewery, and 2,600 homes, does that say anything about the capacity of the countryside in this location to absorb change?
Well, it suggests that proposals for different types of development in different locations may or may not be acceptable.
Well,
And
they've
if
been
those have been
passed.
permission, then those particular proposals in those particular locations were acceptable. Now, I haven't looked in detail at those decisions. I have looked more carefully at Thatched House Farm because details of the report on that were provided. In terms of the solar farm, I've identified where that is, and certainly I don't. Sadly, this was last year and I've not revisited it recently, but I don't think that site would be visible from anywhere near the appeal
Well,
site, potentially not from Hascombe Hill, but I haven't been up there to look. In terms of the fracking site, that was separated from Lydia Park and from Thatched House Farm for that matter, by being the other side of an area of woodland. Although when I did read the decision, there was some acceptance that it would be visible I think it was an exploratory fracking site, but it would be visible for a period of time. But there were comments about the mobility of equipment and the
Indeed,
lack of large fixed structures, etc.
indeed.
But each of those would be considered in its own context of
Well,
energy and as a resource,
I'm
etc.
putting it to you, Mr. Wall, that the inspector consider that the countryside, area of countryside in the round as to what's going on.
To the extent he can be aware of those decisions,
Yeah,
etc.
yeah.
I don't draw any comparison with the fracking site.
And a short point on policy, because I interrupted this morning to say that whereas with Greenbelt, there's a mandatory requirement to attach substantial weight to any harm. That isn't carried across. And I just want to read you a passage from the Protect Dunsfold decision, which is in the bundle before the inspector. I'm just going to read it to you. And it's from the Court of Appeal judgment. It says the decision maker
Can you
is
give me
entitled.
the CD number just so I can read it
Pardon?
at the same time? Can you give me the CD number just so I can read it at the same time?
I don't have it, but it came in with my opening submissions. It's probably an ID document. My internet connection somehow seems to have very conveniently crashed just before my cross-examination.
They are, yeah. So I'm reading through them at the moment. So my
It'll
learned
be
friend's opening statement was the first one, ID 0. And so we've got Royal Courts of Justice and First Secretary Estate 2007, EWHC 1034, that's ID 1, South Cams, Tanzania. So
It
can you
should be
just remind me of
Protect
what
Dunsfold.
exactly the
Protect Dunsfold.
it's not got that. What would be the year that it would have been reported, Stephen?
Well, I've got my copy here. It's 2023 EWHC 1854. Admin.
1854.
Can I just read the passage? It's from the Bayliss decision that my learned friend, Mr. Lintop, will be familiar with. And what was said.
I'd like to read it at the same time if I can. I mean, if it's in there, it should be in there. If it's not in there, we need to add it. Are you sure of that number? Because we've got a Waverley case 2023 EWHC 2161.
That's the injunction case.
Okay. Well, I don't think it is in there then.
Mr. Cottle, do you want to check the bundle of inquiry documents?
I would have to go to the back of the room, sir. Well, the Bayliss decision on the Protect Dunsfold is in the quarry. I don't have the exact reference. Perhaps if I got it.
So I've got your submission and I've got the list of authorities that you refer to within that submission. And you've got Doncaster, South Cams, ZH, Mead, extract from CRE report, Smith, Waverley and Gray, 2161 to be supplied. So that's it, isn't it?
Well, I
be
stand,
supplied,
I
so you didn't
stand,
give us-
I stand corrected. I'm going to learn.
So
If we could give it to my learned friend, because he
We
just
need to
wants to
copy
follow
it.
the passage.
Is it ID 7.3, Mr. Lintoff? That's Smith versus Secretary of State.
No, it's not. It's not that one. It's a different one. It's not there because my learned friend was going to supply it, but didn't supply it last time because he's put an asterisk saying that. Thanks very much, Brian.
All right.
I'm glad I got as far as the asterisk.
So I'll have this copied and we'll have to add it as another ID on the end of the existing IDs, Inspector.
Well, that comes from the inquiry having been staggered over the years, so I apologise because it's obviously, I put an asterisk on it, but I thought it had gone in. It's paragraph 48. My learned friend, Mr. Lintop, will be familiar with it. I've seen it many times.
Witness.
And it's the bit that's underlined. When you finished, perhaps we can just hand it up to the inspector. The decision maker is entitled to attach different weights to this factor
Hang
depending
on,
upon
sorry, look, I've not picked up where you're reading from yet.
paragraph 48. That's the bit that's underlined. It's in,
Sorry, yes, the second bit of
Yeah,
underlining, yeah, halfway through the paragraph.
yeah, the decision maker is entitled to attach different weight to this factor depending upon the degree of harmful impact anticipated. So the short point, Mr. Ward, it's not axiomatic that great weight has to be given to any harm to the setting of a national landscape. It's a question of discretion for the decision maker as to what weight to give it.
Yes.
Thank you.
The starting point is that there's great weight there.
Well, the starting
You
point
have
is
to
what
then
the
decide
MPPF
what the
says,
degree
Mr.
of
Ward.
impact is.
The starting point is what the MPPF says. If we could just pass that up to the decision maker, sorry, it's up to the inspector, sorry. Just so we'll get that copied. It's at paragraph 48, sir. It's the second bit of underlining. And it's quoted by Lord Justice Lindblom in the at the very bottom of the page. It's saying that Lindblom agreed with Sir David Keane's observations in the Monkhill decision, which you'll be familiar with again.
Inspector, do you want us to get some copies made of that now then? Yeah. Yeah. I think
Can I have a copy here, Steve?
A new topic is this that Mr. Smythe did a supplementary proof following on from changes on the PPG and flooding, but I didn't see you do one on the changes to the PPTS. My learned friend took you to paragraph 28 in relation to conditions, but I wanted to take you to paragraph 28 on the tilted balance, because one of the things that Mr. Sibbott did is he produced a CW5, which was a housing decision, where the failure to properly survey was counted as a reason, a significant reason for refusing permission. And my point to Mr. Sibbott was that the inspector still went on to apply the tilted balance. The tilted balance will apply in this case, won't it, Mr. Ward?
Well, sorry, that's it correctly. The reference is to footnote 7, I presume.
Paragraph 28.
Well, my starting point for the tilted balance in 11D is footnote 7. So the policies referred to in this framework, rather than those in development plan relating to habitat sites, or sorry, I thought you were distracted by something, they were finding something. So the tilted balance doesn't apply if the policies in this framework, footnote 7, that protect areas or assets are particularly important, provide a strong reason for refusing. So in terms of those topics, you need to look and see, do they provide a strong reason for refusal? Those policies that are referred to are habitat sites, land designated as green belt, local green, in this case, national landscape, skipping through and areas of flooding or coastal change. So there's a list there in that case in terms of habitat sites, national landscaping and flooding, all of which are relevant to this appeal, which potentially are policies in the framework which are capable of offsetting, of stopping the tilted balance if they provide a strong reason for refusing the development. Sorry, my voice was going.
And we're not in the national landscape.
We're not in the national landscape, but
Thank you.
we are in an area where there is an impact on the national landscape, or we say there is an impact on the national landscape, and the policy that protects the national landscape is engaged.
But you hadn't addressed that in your proof, had you?
In terms of the impact on the
No,
national landscape,
whether or
policy
not the tilted
RE3,
balance applies.
I haven't addressed the
No,
tilted. I
yeah.
don't think I have. No.
No. So I'm raising it with you. And well, obviously we'll move on to submissions, and it's dependent on the inspector's findings, isn't it?
Yes, from the council's point of view, if the inspector finds a strong reason for refusal relating to impact on the national landscape, that disengages the tilted balance.
But if it's not in the national landscape, he won't be looking at that.
Well, he'll be looking at it on the impact on the national landscape because of views within the setting.
We heard yesterday from my client that, and we saw the photograph that was in the heritage mapping exhibit to Mr. Smythe's evidence, and there was a photograph of the land very clearly in relation to the period in September 21, when there was an injunction in force, I should add, on the land. So my client was complying with the injunction by not moving on at that time. The point is that if predecessors in title removed the trees, then that's not intentional unauthorized development carried out by my client.
I will break that down. In terms of the removal of trees is not intentional and unauthorised development, simply because the removal of trees is not development to start with. It may be something that facilitates development, but chopping a tree down is not development.
Well, then the creation of what we know is the beginnings of the hard standing at the entrance to site B.
That is not development for which your client was potentially responsible if that evidence.
It shouldn't get.
But
Well, let him
it
finish.
is that hard standing is development which is a requirement of this application, and which is the forerunner to the laying of a hard standing across the rest of the site.
Yeah.
But the application includes a retention of that area of hard standing. So that hard standing is part of the development proposed for the inspector to consider. But the council's case, it's not an enforcement issue, so the council hasn't focused evidence on it, but substantial additional hard standing has gone down since.
I agree with you that the appeal is requiring hard standing on the appeal site, but the loss of the trees doesn't go into the equation on the intentional unauthorized development component of the decision.
No, I think it is part of the council's overall consideration, certainly from an ecology point of view, it is part of the consideration. In terms of the loss of the trees is not development that counts for intentional unauthorised development.
That was the first question I asked you, and you're agreeing with me. Thank you. Good. Now, on the sequential test, what we saw, and I don't want to take you back to it because there's a pressure of time, but there's paragraph 7028, which deals with a reasonable alternative site for the purposes of the sequential test.
Okay.
And it's a revision from September 2025. It's a new paragraph.
This is in the PPG.
That's right, PPG, yes. So, do apologise. And when it talks about the same type of development as an alternative site, if you imagine that there was a disused hospital or a disused school, for example, in a settlement boundary, and it was a quiet residential area, and there was a sequential test being carried out by a proposal for a skip yard with lorries, a skip yard
Okay.
for a skip depot where lorries are in the habit of getting their motors going at 4:30, wanting to get out and deliver skips before the rush hour. Would the sequential test be passed, in your view, if the disused school or former hospital site in that residential area was flood zone 1 and the place that the depot was appealing for was in flood zone 2? Would you put forward that quiet residential area as a suitable for the same type of development and just look at it in the lens of flood risk? Or would you take into account that actually there's not chance of the skip depot being appropriate, cheek by jowl, with people who are expecting to be asleep at 4:30 in the morning?
I think that breaks down into a number of steps, and trying to keep it simple. In terms of looking at it, is it a suitable site? You would have to look at various factors in terms of access, site size, all sorts of other issues.
I'm asking if you
relevant to
exclude
it.
all of that, just look at it on flood zone only. That's or do you look at it in the wider
Well, he's
context?
trying to answer that. He said he's going to break it down. You've just interrupted him while he's trying to do it.
So you would potentially, if you ticked the box and said that was a site you could operate a skip business from because it would have the size constraints, it would have the access, it would meet the access constraints, etc. of that business, then potentially for the sequential test, you would at least put it into the pot and look at it. You would then maybe dealing with issues you've alluded to in terms of potentially then seeing, is it a site which you would progress to the next stage of? And considering residential amenity or whatever else, then those are things which would potentially need to be assessed at the second stage. But in terms of whether you put it on the table to start with, a site for assessment, then yes, you would. The example probably isn't good because a skip business could have a lot less impact than a hospital, for instance. If I live not far from QA hospital, that is a hellishly busy site.
I'm 2 questions away to the main point, but if, for example, Mr. Woods looks at a site at Culmer Lane and says it's greenbelt and actually there's access is down a public right of way and it would actually be affecting ancient woodland, those are the same sort of considerations as the truck depot and residential amenity, aren't they? So they would come into a sifting process.
My view is the site needs to go into the sequential test first and be considered for the sequential test. And then if it passes the sequential test, that's at the stage at which you put the sifting process in. And is it a site that's suitable put forward as an application? Mr.
Smythe agreed he wasn't a planner and he was putting forward Culmer Lane as a suitable site, and we're going to disagree about that. But from my client's point of view, if he has a particular need in respect of Huey, and he gave us a very graphic, and it was really, vivid, the way he said that it's happened when he's been away and an ambulance is being called, and he's been able to phone back to get somebody to be there with his wife, a really important matter, family support, then surely if we're considering an alternative site for the same reasonable needs that my client has, it is important for him to be on Lydia Park.
No, I can't comment to the detail. On the basis I've been given, it's not compelling to me that the only site possible your client could exist is on Lydia Park. So we'll move beyond that.
Well, we'll make submissions on that,
yes.
And it's up to the inspector, but it would be open to him to find that they have a particular location need.
If the inspector looks at all the evidence and decides that because of the family connections, not obviously just with his immediate family on the 3 pitches he's applying for, but because of ties to other pitches.
Well, he came
on
to
the
Lydia...
opposite side of the track, for want of a better phrase. that those connections are so strong that that is the only site that could meet it,
Of course.
then yes, that will be a consideration for the inspector.
He accepted that, you know, it's the family support. He came to the area for the family support.
Yeah.
And that's,
Sorry, I'm trying to answer your questions, but you'll appreciate from the council's point of view, and I've alluded to the discussions next week, the council will suggest there's a lot of other sites on Lydia Park.
and he wasn't challenged on the fact that he'd asked to buy or to rent another pitch, a site big enough for his family, and he hadn't met with success. You heard that. He gave his evidence.
I can't remember that being said, but if that was said, that was said.
What are you saying wasn't challenged, Stephen, in terms of if you're going to rely upon it, something that's not challenged that you say is particularly significant?
He said, well, I did ask if there was somewhere I could buy. I did ask if there was somewhere I could rent, and there wasn't.
Right.
Okay, I didn't hear that comment. I think if
That's
I
his
was asked to
evidence.
comment on it, it's well, who did you ask, and did you ask potentially in the council's case? I think it's the 28, the owners of the 28 available pitches, because that is potentially a lot of questions of a lot of people.
We have had a finding by Inspector Gilbert, and we have had a finding by a High Court judge, where I was actually cross-examining the officer here, on the question of whether alternative pitches that were being put forward in the injunction proceedings on Lydia Park are being put forward now as places that my client could go to. We've got findings on that topic by Inspector Gilbert and in the High Court that there
I
were
won't
no
waste time going
alternatives.
to it unless I need to. My recollection was Inspector Gilbert said the council said there's no allocated sites rather than no sites on Lydia Park or whatever else, but I will be corrected if I'm wrong. I don't know what was put to the High Court.
Well, I'm going to move on, but I do think that the Waverley decision is in the bundles of cases, and it's paragraph 18, 41 and 94, 18, 41 and 94 that deal with the appellants saying that they couldn't go to Lydia Park and the council saying you can go to Lydia Park, and it being found that they couldn't go to Lydia Park.
Inspector will have to hear evidence on that next week.
On the question of the exception test, when it comes to the benefits, the reinstating of the watercourse would be a benefit, a wider benefit.
It would potentially be a benefit. I commented in chief earlier, the issue is whether it's a wider community benefit. And if I wouldn't count it as in favour of the application if all you're doing is reinstating a watercourse which shouldn't have been removed in the first place. I did say I think it would be a wider community benefit if you were improving the watercourse and wider drainage facilities to potentially reduce the overall risk of flood risk below what it was before that development took place.
Well, how
So
can
if you're
the,
just simply restoring, for want of a better phrase, the status quo, that isn't actually a community benefit.
well, our primary case is that it's not a reason, the flooding is not a reason to deter the council for proposing an extra 28 pitches on Lydia Park. But in fact, all those pitches that the inspectors asked about, all the caravans that I've asked about on Lydia Park would benefit from a coherent drainage strategy that deals with the watercourse running along Crocus Lane to the junction.
again, trying not to give flooding evidence, the baseline flood, and I think it's an issue between the flooding witnesses, but the baseline flood maps show what the flooding
Well,
would
I'm
be.
asking you if it's a wider
Well,
benefit.
the baseline flood maps, as I understand them, show what flooding would be based on when the watercourse was there before it was blocked off unlawfully. Or from memory, most of that flooding occurs to the north of the access track and would have extended to the access track. The exception to that is when it has a junction with Stovolds Hill, and there is a small area on Stovolds Hill of, I don't know what, 20, 30, 40, 50 metres wide, where there is a flooding problem on the roadway.
Coming back into Crocus
The
Lane.
situation, yeah, without going into
Well,
flooding,
it's
the
relied on by
situation
Mr.
that's
Smythe.
changed now, and the bigger problem that needs to be solved
Well,
is the issue of that watercourse has been removed.
It's a wider benefit, and another wider benefit, of course, is the public interest in equality objectives. Because, of course, if it advances equality of opportunity, that's not a private matter. There's a public interest, isn't there, in equality of opportunity for minority ethnic groups.
Yes, and that will.
That's a wider community benefit that can be
That is a
counted.
potentially wider community benefit, but needs to be considered in the context
Right.
of what the options and alternatives are.
And one of the critical issues in this case, if not the most critical issue, is whether or not the appellants would have somewhere else to go to if the appeals were dismissed. And that fundamentally alters the balance of factors, doesn't it, as to what weight?
That not being rude, but that's a private benefit rather than a wider community
right,
benefit, but
of
it
course,
is a
of course.
benefit.
But if they don't have somewhere else to go, there's a wider public benefit. And we know from Mark and Matthew's experience firsthand of coming off the roadside, that there's a public interest in avoiding roadside unauthorised encampments. There's a public interest in avoiding that.
If the inspector concludes that there are no other alternatives, and that's an issue for discussion yet, then there would be a public benefit.
And also we know from decisions and case law that there's a public interest in traveller children getting an education and having access to healthcare. There's a public interest.
Yes.
And these are all matters that you could have identified if you'd paused to consider it, but you didn't. Why not?
I'm trying to think what I've said now, but I have recognised and put in the benefits of a settled existence, the benefits of education, the benefits of access to health. So those are benefits which I've recognised within my evidence.
And when my learned friend says sustainability isn't a matter that's counted against the appeal proposal. I mean, how could it if the council are proposing more pictures at Lydia Park? How could it? But no, but it can't possibly be counted against the appeal site in terms of distance from facilities if the council are proposing more sites at Lydia
I
Park.
think my evidence was it was neutral on that one. It was neither the
yeah.
remote from those
But
facilities.
I'm putting to you that for people who don't have anywhere else to go and might have a 24/7 reliance on a vehicle, for example, there's less reliance on a motor car if they've got a settled site than if they're actually got nowhere to live.
That's always presuming there is no alternative.
You're familiar with the considerations that are set out under paragraph 13 of the PPTS on wider sustainability issues affecting travellers. And that's something, wider sustainability issues, that this inspector could count on the community benefits side. Now, one other challenge that I've got to make, Mr. Ward, is that you said it's not your area of expertise, but in paragraph 8.2 of your proof, if I could take you to 8.2. Just nearing the end, sir.
I'm there.
Paragraph 8.2 discusses general need, and the paragraph 8.4 in the second sentence. Now, the reason I'm asking you this is because this morning, in answer to my own friend, Mr. Masters, you seem to be distancing yourself or relegating yourself by saying it's not your area of expertise and it's Mr. Jarman's corner, not mine. But there in paragraph 8.4, you're saying you're confident in Mr. Jarman's appraisal. And that's about the sufficiency of need being met. And I'm asking you, Mr. Ward, how in all good conscience you could possibly have endorsed Mr. Jarman's view if you knew, as you do, that since the GTAA was carried out so long ago, I think the base data was December 2017, there was the 48 different permissions that you referred to in your table we've seen earlier at paragraph 4.54. You knew that there'd been no fresh assessment of new family formations from then. You knew that there'd been no assessment of the number of planning applications that the authority had received, and yet you still had confidence in Mr. Jarman's evidence. You also knew that what Mr. Woods was saying is that in his experience with the fresh GTA, with the fresh definition, councils are finding an increased amount of need. So how were you confident in Mr. Jarman's appraisal when you knew of these obvious flaws?
I'm sorry, I don't accept that there are obvious flaws, and for that reason, I will point to a couple of things which I think Mr. Jarman refers to and I refer to briefly. We both refer to the comments of the local planning inspector in 2023, who looks back on I'm clearly paraphrasing this now, but looks back on the GTAA on the delivery of sites since then and the sites that have been permitted since then. And the sites that are then being put forward in the LPP2 and comments that he is satisfied that the needs of gypsies are met and that the policy then of the allocations in the plan are then sufficient. So it was reviewed by the inspector in 2023, much closer to that date, and to Mr. Jarman's evidence, as I think was mentioned earlier, which and again, I haven't read it for several weeks, but refers to the fact that the 2018 GTAA took account of not just old definition, but new definition. So travellers for all purposes.
My questions very quickly, but you knew that there'd been a number of subsequent permissions since the plan was adopted. You knew that since the EIP was carried out, a number of subsequent permissions, and you knew the data was by then 5 years out of date. How could you put forward that there's an up-to-date 5-year supply if there hasn't been a recent appraisal? How is it possible to say there's an up-to-date supply if the data is so old and you know that there've been subsequent permissions granted that haven't been assessed?
My primary reliance was probably, and things have clearly moved on because this is almost a couple of years ago now, but and clearly I've now read the new GTAA, etc. But I'm casting my mind back to before that, was largely relying on probably the inspector's comments in 2023.
Well, the fact that you could endorse that position, Mr. Ward, really brings into question your other judgments. On the Thatched House Farm decision, do you go along Mr. Sibbert's route that it wasn't a regular decision of the planning authority, or is the planning authority's representative today? Are you saying the Thatched House Farm permission, where assessments were carried out about the newts and the wood white butterfly and the protection measures were conditioned. We've seen the conditions that were attached to Thatched House Farm, and I'm putting that forward as an example that the inspector can properly address the concerns by conditions. And Mr. Sibbert's response was, well, I don't think that was the right decision. Surely from the council's point of view, as a representative of the council, you don't have any misgivings. You think it was a correct decision.
I wouldn't want to waste too much time on it, but the Thatched House Farm, this is from memory of having read it, was a decision which did have ecological reports that went in with it. Yes, there were conditions which required further details, but the council was satisfied at the time that the ecological report submitted with the application provided a fairly thorough basis on which to make a decision, albeit that then further ecology conditions were attached.
Well, how do you want,
which is different to the situation we faced here based on Mr. Sibbert's evidence of the inadequacies of the ecology reports which were put in with these applications.
Yeah, well, you're agreeing that the Thatched House Farm was a proper decision. And how do you answer the rhetorical question that I was asking Mr. Sibbert, which is, how do you explain to my client that where he'll be living be loss of habitat of greater crested newts and wood white butterfly that the Thatched House Farm is trying to encourage, part of a project trying to encourage, when the very source of the great crested newts in the pond has 3 barns being put up for a brewery, and the very site of the project for the white wooden butterfly is allowed to build 3 barns. How do you explain that to my client?
Well, without delving into it and looking, my recollection from having read it was the council was satisfied with the surveys which came through with that. Now, I'd need to go back in the report and arguably into other details to see what reports were submitted. The omission, I think at that time, and again, this is from memory, is I don't believe whitewood butterflies were on the agenda or considered as part of that application. And I don't know why not. But I think that decision and report has been put in before the inspector. So he'll be able to read and see what was considered on that one.
I would prefer to leave for submissions the questions I was going to ask on the PPG on conditions, because I'm assuming the Secretary of State's knowledge on the paragraphs that I'm referring to is about negative Grampian, which might save a permission from otherwise being dismissed. And there is an exhortation in the PPG and indeed paragraph 56 of the MPPF and paragraph 28 on decision makers to see whether a proposal that's otherwise unacceptable might be saved by a condition. And I think the point really is whether a negative Grampian that precludes the permission from taking effect in this case. So it's like, if you can think of it, the British Railways Board case, which went up to the House of Lords, where they were seeking permission for development of land, where the corner access was owned by Hounslow, who wanted to reserve it for conservation and had no intention of selling the land to British Railways Board for the purposes of their access. And it was refused on the basis that it wasn't land within the control of the developer. And the House of Lords was saying no, that we often have planning applications made in respect of land that's not owned by the developer. And if it's a suitable land use and they don't get it, then that's tough. But they may obtain it at a future date. And this inspector can grant a Grampian condition that requires works in terms of a coherent drainage strategy. And if my clients can't do it, they don't get permission. But if they do it, then the permission takes effect. Do you see the point?
I'm sorry, I'm losing your language because you're saying if they don't do it, they don't get permission. If you're suggesting it's a Grampian condition,
if they don't comply,
the permission, what you're saying is the permission will be taken away.
The permission is familiar. We've got it in the Lawn Hill decision as an example, where you've got a retrospective permission, which is saying that the permission will cease and won't take effect unless these steps are carried out.
Inspector, these aren't questions that have been put at the moment.
But I can put it to you, Mr.
Are you-
Ward.
are
It
you-
is possible for him for the
Right.
inspector to grant a negative grampian, including the drainage outside of.
I would like to, I will comment if I can see the wording of one, but I've not yet seen a wording of anything that would suffice.
Oh, well, we'll deal with it in the condition session. It doesn't have it. It says pre-commencement. Yeah. We'll come back to that topic. Thank you very much.
Is that it, Mr.
It
Cottle?
is.
The council's argument that there are pictures which could be made available because they're occupied by people who aren't from the gypsy and travelling community. And I just wanted to know how the council reaches that view, how you can be confident that presumably occupancy conditions are not being complied with.
It's an issue that might come up when we look at need and CW 16B. But C16B, I've set out a table at the back of it in terms of those pitches there and who the council understands to be occupying those pitches. I can go to it if need be, but I thought it was something we're discussing next week. And that is based on two lots of factors. Primarily, it's based on information from Mr. Jarman and the survey team who
Well, it's to do with
undertook.
Mr. Jarman. Let's leave it till
It's
next week.
comments that.
Yeah.
It's also based on the council's enforcement officer and his investigations on site.
And Inspector, if you check your notes from the last round table, you'll see that the precursor to that table was CW 16A.
Yes.
And we discussed that and the evidence at that time. So you've got some good notes on there.
And then the other area I wanted to ask you about is the nearest settled community, which you've commented on. And I'm looking at your appendix CW9, which I think includes CW9.
Right. Oh, the map, yes.
Yes, and I think that includes the places that you mention when you cover it, referring to that point in your evidence. And I wanted to know what the basis was for including those areas, because I think you include Stovolds Hill, but you also include Thatched House Farm, which is
In the opposite direction.
in the opposite direction. Yes. So I just want to understand how you came to that view.
Largely in the straight answer, it's based on Inspector Gilbert, who chose
Well, I
that
noticed
that was a settled community and included Thatched House Farm. Personally, I would probably not include Thatched House Farm, although I hesitate. I would not include Thatched House Farm necessarily as within that same settled community, although I think it is a property which is at least as closely affected by development on Lydia Park. But there is a settled community who seem to identify with Stovolds Hill, of which the residents of Thatched House Farm are closely associated. So you know.
So are you taking Thatched House Farm out? I just want to understand which area you're looking at when you.
I think the primary area is the area which regularly travels past the site, etc. Whether you include Thatched House Farm, I don't think makes a great deal of difference. But you will see on Stovolds Hill, all those properties are well scattered. And in terms of them being well scattered, Thatched House Farm is is in distance terms, not that much further away.
And when you talk about Stovolds Hill, are you including not only Stovolds Hill, but there's another road going off to the east, opposite High Stovolds Farm, with a number of properties on? Is that, does that fall within your understanding of the Stovolds Hill area?
Sorry, which way to, oh, the road that called Hall Place going down to Hall Place Farm?
Going down to Hall Place Farm, yes.
Yeah, I believe that the properties down there, there's a number of properties off that track.
Yes.
That they are part of the community of Stovolds Hill, yes.
What's the name of it? The road?
It doesn't have a name on this plan.
It
Oh,
says
sorry.
here.
Hall Place Farm, Mr. Masters.
I like the figure of about 20 because I admit I walk the area and I struggle to work out quite which 20 buildings are in and are out, but there's a scattering of dwellings
Yes.
of about 20 in number.
Altogether.
Sorry?
Altogether about 20.
Yeah.
And final question on Thatched House Farm, which I've heard that there's a brewery there. Is there a residential use there as well?
Oh, yes. Thatched House Farm, if you look on that same map, top left-hand corner,
Yes.
where it says Thatched House Farm, one of those buildings, I think the larger the building is the residential
Right.
unit.
So there is a house there.
So there is a house
Yeah.
there, and then the brewery buildings are the ones which go back up towards Dunsfold Road,
Right,
top
okay.
left corner.
Thank you, Mr. Ward. Mr. Lintop, please.
To add, sir, that when Mr. Ward said that the council officers had been to the site, when we're
Sorry,
talking
which site was?
the one with the non-travellers in relation to the first question you asked,
Oh, yes, yeah.
Mr. Jarman has put forward that the PDAs are based on robust evidence. You don't have the enforcement file. We don't have the answers that Mr. Jarman got. There isn't a.
No, I'm going to cut you off, Mr. Cottle, because I've agreed we'll take that up with next week.
Right, I just wanted to put down a marker whether we might have a request for disclosure of the information, obviously redacted names, on which this conclusion has been reached.
Inspector, at this stage in the inquiry,
Yeah.
when we've been going for years, I mean,
The request could have been made earlier, Mr. Cottle, for that. I think we'll deal with what we've got next week.
So, Inspector, moving on to the re-examination then, I'm going to take my learned friend Mr. Cottle's re-examination first. And there are 4 questions that I want to ask, possibly 5 on that, and I'll flag them up as we go round by issue. And then there's a couple of points that I want to ask on Mr. Masters' cross-examination as well. And the first point about that is your judgment was called into question, Mr. Ward, right at the end of that cross-examination. And how on earth could you at 8.2 be having confidence in Mr. Jarman's view that there was a 5-year supply based upon your position in 2024 and the LPP2 inspector, you said, having looked at it the year previously. Can I just remind you of the Burnt Hill decision of Mr. Peter Willows, which is dated June 2024, so a couple of months before your judgment. Does the fact that he concluded there was a 5-year supply, as is in the evidence,
Sorry, I'm going to object.
help you with
I'm
deciding whether your
one moment,
judgment
Mr.
was whether your
So
judgment
it's
was
not, it's
defendable?
it's leading to take this witness to an appeal decision. You can ask him where his judgment comes from. You can't say, oh, by the way, this,
No, it's not leading.
it is
It's
leading.
no more leading than other questions that have been put on behalf of the appellants.
So the question is, given the context of the Burnt Hill decision and what Mr. Willow says, are you confident?
I do
in your
apologise.
judgment?
Just one moment, Mr. Linton.
The point about that case is that there was no contest on the issue. It was just agreed.
You didn't put it to him, and you called his judgment into question when an inspector had come to the same judgment just months before, and I'm quite entitled to ask him.
It's relevant to the cross-examination, Mr. Cottle.
So, having looked at Mr. Willow's conclusions, can you help the inspector whether that gives you confidence or not in your own judgment?
I'm happy to go to Mr Willows and look at it if need be.
You
or
don't have to do that, just the fact you made that
I have read
determination.
Mr Willows' judgments. I haven't got them in front of me. I was probably aware of them at the time that I wrote 8.4. I can't say with confidence, as 100% certainty I was, but certainly, yes, they are. They would have been part of the consideration.
And does it give you, or does it not give you confidence in your judgment at that time?
Yes.
And so the second question is in terms of Inspector, the flooding issue of community benefits. Remember, you were asked about wider sustainability benefits. And Mr. Coppell put some questions to you about the public interest in having sites in not having people on the roadside. What I wanted to ask you is, what should the inspector do if it's suggested that there are benefits, wider community benefits, going both ways? How does he come to a view as to the composite issue of whether there are community benefits for the purpose of policy?
Well, he needs to assess what those or the magnitude of those benefits compared to the various degrees of harm in the appeal. And specifically in terms of flood risk.
And if he was of the view, just hypothetically, that there were some community disbenefits and some community benefits, how should he decide whether overall there are community benefits, wider community benefits, to weigh against the flood risk? How does he do that?
Well, clearly, if the situation is either neutral or the disbenefits are greater, then there will not be wider community benefits to outweigh the risks of flooding.
And then, Inspector, moving on to the issue of the sequential test, Mr. Coppell suggested to you that a relevant consideration in terms of the sequential test was his client's situation in terms of potentially having help from people in the wider Lydia Park community. And my question for you is, where the sites you're relying upon are sites which have sufficient capacity to accommodate 3 pitches, which is what the application is for. Are those, if there were wider benefits relating to Lydia Park more generally, is that relevant to the sequential test, given what you've said about Inspector Hand's determination and it being limited to flooding considerations?
No, in terms of if there are pitches probably on the allocated sites, if there are pitches potentially available, then they simply pass the sequential test. Caveat, I suppose, that say unless there were exceptional reasons that they were so far removed or so distant from those other benefits that they could be discounted. But within the confines of the sites considered, I wouldn't consider that to be the case.
Well, that would be a width of search issue, wouldn't it?
Yeah. That's why the search area is potentially the area in which those sites could be accommodated and could meet the needs.
The fourth question, Inspector, is on intentional and authorised development. And you were asked some questions about the relevance of the trees. And it was said that that was where we were looking at in terms of this biodiversity issue. And it was suggested to you that, and I think you accepted, that the trees themselves, obviously they're not development at all. But the question is, bearing in mind the approach of inspectors such as the ones that we've looked at in the evidence, where development takes place which causes damage to trees or the felling of trees, such as at Burnt Hill or Loddington, is that something, that consequent damage, which is relevant to the issue of intentional unauthorised development and the weight you give to it?
Yes, if the development will itself cause harm, then the degree of harm is obviously part of the consideration of what the harms of that development are or would be.
Fifth question, and it is actually the penultimate question, Inspector. I know I said 5, but I was mistaken. There's actually 6 questions for Mr. Cottle's evidence. He referred to paragraph 28 of the PPTS, which, if you recall, is the paragraph which relates to if there is a failure to demonstrate a 5-year supply of pitches, then that's something which would trigger the tilted balance or engage paragraph 11 of the framework, and the tilted balance would need to be considered. My question to you is this: Mr. Cottle put his point about the tilted balance on the understanding that the tilted balance had first been engaged. What would be the case if, as you have suggested, the inspector finds that there is no failure to demonstrate a 5-year supply in respect to the tilted balance?
Well, effectively, and I referred to footnote 7, and the policies of the framework as referred to and clarified in footnote 7. So the tilted balance would not be engaged.
But what about if there is no, I mean, if the tilted balance is engaged by having a failure to demonstrate a supply of sites in accordance with paragraph 28, what about if there isn't a failure to demonstrate a supply of sites? In those circumstances, is there any issue as to whether the tilted balance is engaged?
The presumption is on 28 is simply that there isn't a 5-year supply. If the inspector finds that there is a 5-year supply, then 28 doesn't get engaged.
We would agree that.
I'm grateful. And then the final question, question 6, is in terms of the national landscape, which is where my learned friend started off. The question for you is this: you've said that that's an issue, that the issue of the development within the setting of the national landscape is something to which great weight should be applied, and it's a strong reason for refusing permission if we get to looking at footnote 7 policies. My question for you is, my learned friend took issue with the amount of weight. Does the inspector, other than the analysis of Mr. Dudley in 4.27 to 4.29 of his rebuttal evidence, does he have any other evidence from a landscape architect as to the degree of weight that you should attach to those considerations?
He certainly has no other evidence from a landscape architect, and I don't believe there was even any evidence from Mr. Woods in terms of impact on the national landscape.
So, Inspector, moving on to Mr. Masters' cross-examination. Trying to read my own writing here, which is pretty hard sometimes. So, Mr. Masters started off by, and apologies for not grouping this together, Inspector, because it's another question about need in respect of how that sounds in policy. But he began by taking you through AHN 4, and he spoke to you about the relevance, if any, of there not being any current allocations to deal with the situation post the current GTA being produced. So my question is, well, given that Mr. Jarman identifies a target of, in his evidence, 50 and a supply of 58 in the PDA, in those circumstances, how relevant is it as to whether or not at this stage there are any allocations within any plan document relating to gypsum traveller site provision.
Well, very simply start with, there are still some allocations which have not been taken up, but in terms of the updates on that provided by Mr. Jarman and the issue of the PDA, the purpose of that is as an informative document to the council as what the potential supply of sites is. So although many of those have not yet had the opportunity to be allocated, the purpose of the document is to examine need and supply and to provide advice and guidance on where the supply of sites will come from.
So the next issue, Inspector, is the situation of cumulative impacts. And this is something that you deal with within your proof of evidence. And you said you couldn't recall the case that you referred to. On page 57 of your evidence, you discuss the principles within the Tracy Holland case. Page 57, CW12. And so the question for you is this. It was, I think, suggested by Mr. Masters that that wasn't a relevant consideration, or may not be a relevant consideration. And given the council's position that there's more than sufficient harm to be refusing permission on any one site, that may be right. I want to put to you a hypothetical question. If the inspector formed the view, that there wasn't sufficient harm to justify refusing permission on site A or B or C or D individually, but he formed the view, as in the Tracy Holland case, that should permission be granted in respect of all of those, cumulatively there would be harm to landscape or whatever interests. Is that a relevant consideration that you say is something he should be looking at and taking into account?
Yes, it certainly is, and it's probably not a common scenario, but it'd be very difficult for that not to be the case if an inspector decided that 2 or more sites were unacceptable and was faced with then having to make a decision of A or B in order for the harm to be kept to a suitable level. So it's got to be a consideration that if there are several proposals which collectively will be unacceptable, then that is a consideration in the decision on each one of those.
Mr. Lincoln, can I just
Yeah.
check what there actually is at Appendix CW12? Yes. That's what I've got. It doesn't seem to marry up with.
Yeah, so 6.77. He says he's produced
Yes.
Tracy Holland, doesn't he? But you're right, because I know that the Stevens case is in there as well. So that's something I hadn't spotted, Inspector. But yeah, well, my learned friend's quite right. So
yeah,
I mean, he's given the well. I apologise, Inspector, then that you haven't got that case
No.
in the bundle of documents before you. But he's discussed the principle of it there, and I will obtain that.
I can see it was the intention, but
Yeah.
the
I
context isn't there.
apologise as well, because something went wrong in the compiling the appendices.
So, Inspector, I'm making a note, and when we give an ID number to the Protect Dunsfold case that we've got, we'll also do the same for that. Yeah. So, Inspector, moving on then to the third point on Mr. Masters' cross-examination. And it's about you were asked, the next point was about buildings within the AGLV. And Mr. Masters suggested to you that, well, having these buildings would cause an impact. And you said, well, buildings like that would cause an impact. But the question for you is, when considering whether or not that impact is positive, neutral, or negative, whose evidence does the inspector have to help him make that determination?
I can't turn up the reference now, but I'm fairly sure that those buildings are assessed by Mr. Dudley, probably in his rebuttal.
And is there anywhere else the inspector sees an assessment of them other than in his expert landscape evidence?
In the appellant's evidence, no. I believe
So that's
Mr. Rowe
not, that's
makes.
not true. Mr. Rowe produced the decision letter and the assessments in the decision
You
letter. but
interrupted the question where I said, I believe, follow on, which was going to be Mr. Rowe does make reference to them.
So
Right.
And that's why I believe they're then addressed by Mr. Dudley in his rebuttal, because
But so, Mr.
Okay,
Masters,
okay.
so what you're saying is that's addressed by Mr. Dudley, but
in
also,
his rebuttal,
but you've also acknowledged that there is reference by Mr. Rowe.
they're addressed
Yeah.
by Mr.
well,
Rowe.
there certainly is a spec. I mean, in terms of the evidence, Mr. Rowe, he said, if you remember last time, that you wouldn't know that they were not agricultural buildings unless you'd actually read the permission. So he recognised they were there. That's why my question was about the quality of the evidence before you in terms of the nature of the impact. And that's what the witness was answering, saying that he's got the landscape impact evidence.
So what you asked him is, you asked him about where does the inspector get the evidence, the assessment from? And the point that I made is that they, not only were they assessed by Mr. Dudley, they were also assessed by Mr. Rowe. They were assessed by Mr. Rowe, both orally and in his written evidence and in the decision letter he produced.
Well, Inspector, you've got your
Yeah.
notes of that. And so the fourth question, fourth question is in terms of the dominance of the nearest settled community issue. And I just want you to have a look again at the framework, not the framework, sorry, the planning policy for travellers sites that my learned friend took you to, and in particular policy C on paragraph 14 on page 7 of that document.
Yes.
Now, do you recall my learned friend asked you to underline the word scale when you went through there? So paragraph 14 says local planning authorities should ensure that the scale of such sites does not dominate the nearest settled community. In terms of the way that Inspector Gilbert dealt with it and the comments that my learned friend then made, can you just have a look back at Inspector Gilbert's decision, please, at CD 38.8.
No, I have the judgment. Is this paragraph 13 or 13?
Yes,
Paragraph
that's the one.
22.
Paragraph 13 of that judgment. So given what she says in that paragraph, and well, indeed in paragraph 17 as well and paragraph 20, what's your view as to whether or not she's looked at the matter properly in terms of the scale and the relevance of scale in her assessment?
Well, 13 largely focuses on the sites to the south of the track, with which comparison's the wrong word, but she draws attention later.
It's more 17.
Paragraph 17 actually directly addresses policy C and states assessing the suitability. Authority should ensure the scale of such sites does not dominate. So that's part of her. That's a prequel to the details that follow. And then in 20, she talks about the number of sites. This would numerically increase the existence of dominance of Lydia Park. Spatially, the extent of land occupied would also increase. And despite the site's location on the far side of Lydia Park, this would be apparent as people travel past. The increased extent of sites along Stovolds Hill despite the proposed landscaping. So the focus was on the spatial impact of that numeric increase.
So I'm going to interrupt because this witness, I took him to scale because because of course he ignored completely numbers. And then in paragraph 22, this witness conceded that what in the conclusions of the inspector, he looked both at numbers and spatial effect. And that's quite clear from paragraph 22.
Sorry, Mr. Masters, you're saying?
So I took him to scale.
Yes.
Because that's all he'd relied upon in his evidence in chief. And my cross-examination was actually, there were two elements, numbers and scale. I took him to paragraph 22, where the inspector makes it quite clear her finding isn't just based on spatial effect, but also
Yes.
on numbers.
I see that. Yeah.
And so the next point, Inspector, is in respect of sites which you recall Mr. Masters asked you about whether there are any publicly available sites when looking at the next part of his cross-examination. The question, the simple question for you is, does a site have to be publicly available to be sequentially preferable or not?
No.
And the final question for you then is this. Yes, the final question is this. Mr. Masters talked about a temporary permission and he asked you about the length you felt would be needed in order to provide a temporary permission. But he didn't ask you your view as to whether or not such a permission was in any way justified. So can I just ask you for your conclusion on that?
Well, it was phrased as a question of what temporary period would be needed for some form of Grampian condition to address drainage matters. So it is very much how long would it take for some form of drainage works or whatever. But in the wider context of would I support, on the basis of the evidence I've heard, a temporary permission? The answer is no.
Inspector, those are all the questions I have. Thank you very much.
Could I just add, for the sake of the record, that when landscape evidence was being given by Mr. Dudley, I was cross-examining on views out of the national landscape towards the appeal site regarding, I think from recollection, I think it was photograph 7, which is the nearest point as you go up from the corner of Dunsfield Road into the national landscape and look back on the site, which is the closest view that you get. Our case was being put on national landscape because my learned friend was sort of describing it as that all you've got is Mr. Dudley's evidence, but actually you heard the basis of him being challenged, and it's up to you to reach your own view on that. It's not imperative that you have to accept Mr. Dudley's assessment of the view. He was cross-examined on that, and you're entitled to reach your own view on it.
Well, it's always understood on character and appearance that is the case, Mr. Cottle.
Mr. Wood took the view that there wasn't an impact on the national landscape, and you were asking him questions about why is that, and he answered that because of the proximity, not being immediately adjacent, but we know the road and the national landscape and the relationship between the two. But you have to take your own view on it. Just because you've got Mr. Dudley's evidence doesn't mean it's all one way.
Yeah.
Thank you.
Thank you.
Next up is Mr. Woods. I suspect we're just under 2 hours now. I don't think we're going to get much. If your estimate's the same for examination in chief, I don't think we're going to get much beyond examination in chief by one of the advocates.
That's right, so I'm going to be.
Are you going first?
Yeah. There's no way we'll get beyond. Mr. Woods, I think.
So I'm going to take a short break and then we'll resume at 3:15, please. Inquiry's adjourned.
How you do it, I just find as I get older, sitting for really long periods of time, it starts to creep. Yeah.
the first time in many years my phone has come off. The lunchtime mistake.
It's a capital offence to inspect it.
That happens to hide your touch. Right. No, we're just going to bring my phone was not here with worry. So we use it to very embarrassing. Yeah. Right, I see you've got some. You try and get from something. You're going to be here on Tuesday. Yeah.
Right, time to resume with Mr. Woods. Is it Mr. Masters? You're going first, aren't you?
I am, so yes.
Before Mr. Masters starts, can I reiterate my request for the plan showing the route, a hard copy of the plan that I requested this morning. Haven't received it yet. I obviously don't need it now because I'm giving evidence, but I wanted to have it before I leave tonight.
The route for what, Brian? Which plan? Sorry, Brian.
The route, sorry.
Oh, okay, so. Thank you. So, Mr. Woods, can you pick up your October 2024 proof of evidence?
Okay.
I'm not going to ask Mr. Woods to go laboriously through it, so I'm going to take topics, but I do want you to please go through your first section, which is to identify who you are and your basic experience.
Certainly. I'm Brian Woods. I hold a Bachelor of Arts degree in Town Planning that I obtained at South Bank University in London. Also a member of the Royal Town Planning Institute. I have an ONC in surveying, cartography and planning. With over 47 years experience in planning employed by various local authorities in Surrey, West Sussex, Hampshire and culminating as head of development control at Runnymede Borough Council until 1989. I was subsequently employed as the planning manager at commercial property developers Crest Nicholson Properties, then as an associate of planning consultants Brian Joseph and Partners. I established WS Planning, now trading as WS Planning and Architecture, in 1992, and it's a change here, which I am now a chairman. We act on all sides of planning disputes for developers, landowners, local authorities and local residents. I've appeared as an expert witness at inquiries and hearings on behalf of local authorities, companies, residents, associations and landowners, covering proposals as diverse as B1A, office developments, industrial developments, housing proposals, A1, A3, A5 uses, proposals related to conservation areas, development relating to farms, and use of land and buildings in the countryside and the greenbelt. I presented papers at seminars relating to gypsy site provision and handled many appeals relating to gypsy traveller sites. We have carried out studies for local planning authorities relating to both gypsy traveller site provision and showman sites, and attended examinations in public relating to gypsy traveller matters and presented expert evidence in the High Court. I can confirm that this evidence which I have prepared and provided this appeal in this proof of evidence is true and has been prepared and given in accordance with the RTPI Code of Professional Conduct 2023, and I confirm the opinions expressed are my true and professional opinions.
Mr. Woods, you're instructed, not on all the appeals, but on appeals A and B.
That's correct.
I wonder if you could just.
With a slight nuance, because in respect of
C and D.
the other appeals, yes, we did because the division of responsibility relating to work was that I will be dealing with need across all the sites. So the combined document we submitted related to need and supply rebuttal was on behalf of all the sites.
Yes.
That hasn't been made clear. It came in from your company, and I've taken it as evidence in relation to A and B only. That's how it appeared and was sent to me.
It does say it in the document, sir, actually.
It's on page 2, sir, introduction. For completeness, this is the paragraph 1.2. For completeness, the appeals are as follows: A, B, C, and D.
Yes, those are the appeals.
And then
Yes.
I say at paragraph 1.3, it is understood that Mr. Rowe, on behalf of the appellants of C and D, should adopt the position provided by Mr. Woods, me, in respect
Yes.
of the appellants within A and B.
Yes, I know that.
Okay.
But you've been at pains to say that you're not instructed on behalf of the other appellants. You said that several times during the course of the inquiry.
Correct, except in relation to need and supply, because that was already the division of responsibility, and we hadn't got to need and supply.
Yes, I know.
On the
So that's
agenda,
why
sir.
I've raised it. So
Right, okay, I don't think that had been made clear to the inquiry.
That's why I'm making it clear now, sir.
Hmm.
So Mr. Woods, if I could go back, because I think it might be useful. Do you have your own personal knowledge of Lydia Park?
Well, I've visited the appeal sites. I've not got personal knowledge of visiting the site prior to the instructions relating to the appeals that we're dealing with.
Sorry, that was my fault. Just a general, I'm just wondering when you first, I'm not talking about Lydia Park in terms of the appeal sites. I'm just talking about Lydia's Park, the the Gypsy site, and how far you go back as somebody who knows about these sites?
Well, I can't-
Generally,
Well, generally, in terms of our assessment relating to need and supply, then that is something we've done in connection with the appeal documents originally submitted and the latest submission. Prior to the submission of the appeals, I didn't have any direct knowledge. I've not been to the sites.
Thank you.
Prior to the submission of these applications.
Prior to the submission of the application, I visited immediately prior to the submission of the applications.
Yes.
And I've subsequently visited appeal site B
Yes.
during the course of the appeal once that was submitted. But I can't say that I've visited the site or the area specifically relating to other things prior to that.
thank you. Did you prepare appeals A and B?
Yes, we did.
If we could go to your page 6. You'll see that you list the 4 reasons for refusal.
Yes.
Were there any other reasons for refusal?
No, there's 4 reasons for refusal on both appeals, A and B.
Can I turn first of all to reason for refusal 1, which relates to harm to the intrinsic character and beauty? You've already given evidence about the effect upon landscape, haven't you?
Yes.
Was Mr. Lintoff in the room when you gave evidence about the effect on landscape? Because the question he asked earlier on today, the only evidence that there was came from his witness. Is that correct?
Well, he was, no, it's not
I
correct.
think the
He wasn't
question
in the room.
was the only expert evidence on landscape.
Mr. Woods, do you consider that your evidence in relation to landscape is one that the inspector is entitled to take into account? And what experience do you have to be able to give that sort of landscape evidence?
Yes. I'm an expert witness. I do not have a landscaping qualification, but through my experience that I've had in numerous cases, hundreds, thousands probably of cases, then I consider that my view should be properly taken into consideration in the balance.
How many inspectors are qualified landscape architects do you know? Is it the majority of inspectors who give an opinion, a decision on landscaping? Are they qualified?
No, it would be the minority.
And is it considered that they're capable of reaching a conclusion on landscaping evidence?
Well, yes.
Is there any reason, therefore, that the inspector should take your views on landscaping evidence, fail to take your views of landscaping evidence into account because you're not a qualified landscape architect?
No.
Did you give views on the issue relating to the area of outstanding, sorry, the AGLD?
Sorry, did I give views on the?
On the.
Oh, yes, landscaping issues. Yes, the site was not in a national landscape. It was adjoining it.
If you remember, I don't want to recap all these issues because I'm not going to go there, but one question arises before it. We know that when the AGLD was originally first proposed, there was a review as to whether or not, to the extent of which areas of the AGLD would be included or may be included in the national landscape. That exercise has now been completed, and no additional areas in this area have been included.
No, yes, it has been completed and waiting for the final report to come out. But the appeal sites, A and B, for your purposes, A, were not in a candidate suggested for inclusion within the national landscape.
So we're firmly in the basis of potential views from the national landscape or the setting of a national landscape. We're not in a situation where there's any impact on the national landscape itself.
Yes, that's correct.
Can you help me about this? What, in the context of the AGLD, when the changes take place next year, what's going to happen? What's your understanding of where we will be in terms of the AGLD? And any weight to be given to it?
Well, limited weight because it's a local designation, not a national designation. And that was the purpose, one of the purposes of reviewing the boundary for national landscapes as to whether to include other areas within it. And so it becomes covered by that policy, as it were. So there will be limited weight given to those landscapes outside of the national landscape.
So I'm not, Mr. Woods has already given his evidence when we had a session on the impact of character and appearance, and I wasn't going to go back over that. Although there have been questions asked about it with others, I don't think it'll be of assistance to you to ask Mr. Woods to recap on those matters. So just because I'm not asking him to go back over that, I hope nothing will be taken of it. What I'd like to do though is to go to reason for refusal 2 on your page 6.
Okay.
The proposal sorry, sir.
Page 5.
The proposed development would sit outside the established Lydia Park boundary, or would constitute an extension of this site. The scale of rebuilding and large sites taken together with adjacent new sites to the south would dominate the nearest settled community, contrary to policy C. Now, before we go to policy C, there's a sort of independent issue here that I want to ask you about, okay? And it relates to the boundary of Lydia Park, the road.
Okay.
And it relates to, because I think actually you could split that objection into 2, really. One relates to scale and appearance, and one relates to the existing extension of Lydia Park to the other, to the north. And I want to ask you about the extension.
Yes, I suppose, yeah.
Lydia
It
Park.
sits, if you take the first sentence separately, yeah.
I want to ask you about the extension of Lydia Park to the north. First of all, is there any policy that you know that the council have that says that road is the boundary and no gypsy sites will be extended beyond that?
No, and it's quite odd really, because when you look at the allocations, proposed allocations in the assessment the council produced, what do they relate to? They relate to extensions of existing sites, not new sites, extensions to existing sites. So one could consider, in terms of the new emerging policy that the council have, that actually this would be ideal, because it would result to an extension of existing sites.
I want to compare this with Dunsfold Aerodrome. Would it be appropriate for the council to have said, oh, we're going to give you the 1,800 homes, but we're not going to allow any extension of Dunsfold areas beyond a certain arbitrary boundary, per se, without any consultation or doing anything more?
No, and because of course that's been through a local plan process for the proposed allocations and applications to follow, and work has started on the site. So it was a long process that went through there. What we have here is the council have had the consultants produce the GTAA and then done their assessment of delivery of sites, but the delivery of sites has not been subject to any public consultation. And I understand from yesterday, also I wasn't here, I was updated. and no doubt I'll be corrected if I'm wrong, is that the parish council said they'd got no idea that more sites were being proposed in Lydia Park.
Well, that's what I just wanted to ask you, but I wanted to ask you about consultation in a slightly different context,
Mhm.
okay? This case has been a moving feast, okay? A year or so ago, we didn't have the proposals we now have. We didn't have the GTA. The case was slightly different. A year ago, we had reason for refusal 2, which talks about not extending beyond an arbitrary line in the road. And I've just asked you about that in terms of whether or not there was any policy background for that. Were there any consultations with anyone to suggest that that should be an appropriate boundary?
Well, no, that falls in the same category really, because all of the sites that the council are putting forward, where they're anticipating that's where they will get pitches from. Well, it shouldn't just be the council doing that, an arbitrary thing, and then turning up at a public inquiry and saying that's what we're going to do. It should be like all other matters, subject to public consultation. And so it should be given limited weight because it hasn't been through that process. It's been through a local plan process, or it'd been a document that was consulted on and then went to committee and the community, not just around the appeal sites, but elsewhere in the borough. Borough had the opportunity to comment on it and say what they think about it.
So is there any discussion document, paper, consequential documentation where the council appears to have been able to argue a justifiable reason why the Lydia Park shouldn't extend beyond the road?
No, there's not. And Mr. Wald, I think, said that he didn't know what was happening in the future with the council. But strangely, on the 15th of June, the council sent out a letter. And that letter was a scoping consultation on the new Waverley local plan. Little more than that. So that's asking residents, businesses, consultants, landowners for their comments on how to go the way forward, which runs out on the 27th of July.
See,
So very early days, nothing to do with sites.
See, I'm having real problems with understanding the policy justification for this, because as I understand the council are now saying that there is a justification for extending sites in Lydia Park south of the road, and they've given their PDA reasons for doing that. And they've set out a discussion document in the form of Mr. Jarman's evidence. But I've seen nothing as to why that an embargo should exist with, in relation to extending Lydia Park north of the road.
Well, yes, and you've also hit on the point there, haven't you? That's the elephant in the room. The council themselves, in terms of domination of a settled community, the council themselves are saying there's going to be more pitches at Lydia Park, not to the other side of the road, but the more pitches there. So
Well,
I find it difficult to understand how they could now argue domination of the settled community when they're proposing more pitches themselves.
Well, look, keep that theme up and go back to the second part of the objection. But think of it in terms of what they're now proposing. The second part reads like this: the scale of the resulting enlarged site. So think of that in terms of what they're now justifying, when taken together with adjacent New Acres site to the south, would dominate the nearest settled community, contrary to policy C of PPTS 2015. I'm really having problems with the contradiction there. That's exactly what they're proposing in terms of scale in relation to the PDA for the other sites. But they're saying that's justifiable, but what's happened here isn't. And I'm wondering if you could give your opinion on that.
And what came first? The appeal applications and that reason for refusal, or the PDA? well, the PDA came second, obviously. So, so at the times that the appeal applications were refused by the council, that's what they considered in terms of reason two. And then 3 years later, they say, oh no, actually, no, we're going to have more pitches there.
So what do you what seems to be the prime mover for the council to come to the conclusion that despite what they were saying in this objection, there's now a complete volte-face about other sites? Was the prime mover the extent of need or something else?
Well, suppose yes and no. One of the prime movers must be the extent of the need. And then, in my opinion, the second prime mover is to go for the easy option of not to propose completely new sites, but to propose extensions to existing sites. And this is a theme which I'll pick up on next week.
In that context, Mr. Woods, I'm just keeping with this, if I can, just for a moment. If the inspector comes to the conclusion, two conclusions. One, that the proposed PDA is not deliverable. And I know we're going to come to that, sir, and I'm not asking you to give evidence about your view on the PDA at this stage. It isn't deliverable, and therefore there's an unmet need that's got to be met somewhere else. What do you say the inspector should, what conclusion should you say the inspector should come to about the suitability of extending across the road and enlarging the current Lydia Park site as is being proposed by these applications?
Well, as I said in answer to earlier question, it would fit neatly in with the council's approach for proposing new sites, which are not new sites, but extensions to existing sites, because it is next to existing sites. So it would be logical to say yes.
So I'd now want, if we can, to analyse the second part of the objection relating to over-domination. But I'd like to do that in the context of, if you could pick up the PPTS, and you could pick up the appeal decision that we've all been referring to, like the Gilbert one. Sorry, I'm trying to say where it is, but I'm not sure I can. Somebody else will probably be able to help us on that. I'm sorry, Mr. Litton. Thank you.
Okay.
Okay, now can we look first of all, because we'll do this in stages. Hold on a second. So if you flag up, sir, the PPTS and policy C, page 14 to start with. That's the one I'm going to go to first. I'll go to the PPTS first, sir. Someone forget to pay the meter. No, you've been around as long as I have, Mr. Woods, I think, or possibly not quite as long. Well, I don't know, perhaps longer. But anyway, we've seen various versions of this domination paragraph,
Yes.
haven't we? I reminded the inspector of earlier versions which took into account assessments that needed to take into account how it would affect educational services and other services in a particular area. I just wanted to ask you about your take on how a person should approach this, particularly in terms of of Public Sector Equality Duty, the Equalities Act and Article 14. And I put forward to Mr. Ward the which he accepted, is that this policy we see here in this gypsy policy, we don't see a reverse policy in the national planning framework in relation to the settled population.
No.
So for instance, when the 1800 homes were assessed, there was no reverse policy as to how the scale of that would affect Lydia Park.
No, no, that's quite correct. You don't see the opposite.
And I want to ask you about the question of whether or not, in your view, that offends with public sector equality duty and Article 14 of the Convention, in your view.
Yes, I believe it does, because it shows an unequal approach.
Does that mean when inspectors interpret this section, they have to take great care to take into account the public sector equality duty and the consistency with this paragraph and law, and look very carefully at the extent to which there are consequences to any increase in numbers or increase in scale? It's not just the need to have an increase in numbers or increase in scale. There's got to be consequences. Is that your view or not?
Yes, it is. And looking at the settled community, let's just take it in stages. Looking at the local settled community, I don't think there's any reason to exclude Dunsfold aerodrome development as being part of the settled community, or the house is not built yet. But it must have a consideration. There's no line on a plan anywhere that says that it should or not include certain properties. And I think the inspector asked about Thatched House Farm.
I did, and I'm just trying to understand what you're saying, Mr. Woods, about, did you say it shouldn't exclude Dunsfold?
Correct.
What do you mean by Dunsfold? Are you talking about?
Dunsfold aerodrome, where the major allocation for houses, and you will see the
Oh yeah, I know
access
about that,
road.
but are you saying that's
Yeah.
part of the settled community?
Yes.
Is there anything there yet?
Well, no, I don't think it's houses there yet,
But you're
But
saying
it's
it's part
the-
of the settled
the-
community?
because the work has commenced on it. Major infrastructure has to take place first, and I think that should be part of the settled community. You can't ignore it, because it's not going to go away. They're going to be built.
Right. Well, let me ask you about that, because this fascinates me. It says the wording is does not dominate the nearest settled community. Okay, and the words I want to look at is community and settled. Okay, because you could read settled in two ways. That's a reference to people who lives in bricks and mortar, but just because people live in bricks and mortar doesn't mean they're a community. What we know about the areas, the houses close to the road, is that there are scattered houses. Do you regard those as a community?
No, it's they are settled. They are occupants in bricks and mortar that live close to the appeal site, very close to the appeal site. But I don't think it can be a community as such. Normally you expect a community to have facilities that go with it, and there aren't facilities that go with the scattered housing that is around the appeal sites and Lydia Park.
Where do you go on this? Because if you have one or two isolated houses within an area, It's always going to be the case, isn't it, if you have a 9-pitch or 20-pitch site, to say, well, they're going to dominate those 1 or 2 isolated houses, if you regard those isolated houses as a settled community. So does there has to be a judgment about what this is really aiming, what this policy is really aiming at? And if so, do you think this policy is really aiming at the circumstances we see here, or at something more of a tangible, settled community?
Yes, and the second part of the question, it needs to look at what a settled community is. And I've had experience in appeals whereby there was a number of pitches, and if you looked at the scattered houses around the appeal site, then those scattered houses were less the number of the gypsy and traveller pitches in that area. However, within 2 miles, there was an established village which had all the community facilities. And the inspector concluded that that was part of the settled community because of the facilities that are there. It's difficult for me to accept that the scattered houses are a community. They are what they are, they're scattered houses.
So if we could look at the decision now.
Sorry, Mr. Masters, I'm
If
having
we could
trouble
look
sometimes picking things up because of the aircon. Where do you want to go?
the Gilbert decision, sir,
Gil-
is where I wanted to go.
Okay,
next.
thank you.
And it's interesting because this is a Lydia Park decision, and she deals with effect on the settled community from paragraph 17 onwards, and she's quoting from the current version of the PPTS. Well, possibly, I think so.
No.
No,
Don't say no.
don't think the wording's changed in that paragraph. So we can see from she picks PPT paragraph 17 policy C states when assessing suitability sites and rural semi-rural areas, local planning authority should ensure the scale of such sites does not dominate. Does she address the issue about effect and the issue of public sector equality and equality of approach?
No, she doesn't address that. I can't see that in the following paragraphs. No.
Has she reminded herself that policies need to have an equal effect?
Not in this section of the appeal decision letter. She may have said something at the end.
Does she ask herself a question as to whether or not a similar policy applies in reverse, and whether or not, therefore, she needs to take great care about how she should interpret this policy?
No, she does not. No.
Does she refer at all to Article 14 of the Convention and Convention rights on equality? And then a paragraph, no,
Well, 1 minute.
sorry.
Paul,
Yeah, sorry,
answer
no,
that question.
You are, sorry, I don't know why. Thought you didn't like the question, so I'll move on.
Strangely, she doesn't, no.
Paragraph 19, she then sets out what the council say about settled community. In the council's view, the local settled community consists of some 20 houses in the nearby hamlet on and adjoining Stovolds Hill and a thatched house farm, which is in the other direction. Alford Parish considered the appropriate figure to be some 21 homes. The appellant does not dispute these appropriate figures. Now, let me just pause there. It doesn't look as though there was a dispute on that occasion about whether or not that area constituted a settled community. Is that your case?
No, it's not, no. And there wasn't a dispute there. It says the appellant does not dispute these approximate figures. My point is that the settled community should be a wider area.
Just pause there. Bearing in mind, therefore, that there was no dispute about that, she didn't therefore need to make her own judgment on whether that constituted a settled community. So if the inspector is going to make that judgment, what view do you think he should come to?
Well, that that is drawn too narrowly, and it should include more properties.
The proposal, she says, at 20 would provide homes for members of a related family. I don't really think I need to take you there, except that she says, spatially, the extent of land occupied would also increase despite the site location on the far side of Lydia Park. Can I just ask you about that? The proposals by the council, will they spatially do the same thing? The extent of the land will be
Yes,
occupied will increase?
they're proposing the intensification of existing sites, and there's some fingers that were not developed that they're proposing to include.
So again, I ask you, how can the council rely upon this decision to oppose this appeal, but ignore this decision in relation to their own proposals?
What's the wrong approach?
I didn't ask you whether it was a wrong approach. I can see that. I asked you how logically they could do that. If the answer is they can't logically, then say that.
Well, that's what I'm saying, really. Yeah, it's not a logical approach.
And then 21, she talks about scale. The council had previously granted planning permissions for sites at Lydia Park, despite acknowledging that Lydia Park needs to be greater scale than the settled community to the south. So we already have a situation where this inspector is basically saying effectively no more.
Yes, the inspector is saying that, but I think the baby's already been thrown out with the bathwater, isn't it? By the council already intensifying Lydia Park. So if it's concluded that the appeal proposals dominates the settled community, then that's already occurred.
Well, just pause there for a second, because this is quite important. The proposals the council are making, the LDA, is it? The document, it's
PDA.
PDA, thank you.
Yeah.
We know haven't yet, it's not a policy. We know it's a draft document that hasn't yet been approved by the local authority, by the council.
Well, I'm not sure whether it's been to committee or not, but it's certainly not a document that's been subject to public consultation where you'd normally expect new planning documents to be given any weight.
Supposing this was at the stage of being a policy document going to a local government, to a local inquiry, do you think the inspector would have something to say about the inconsistency between what they were proposing and this decision and how it viewed things?
Well, I'm sure that will be a consideration for those attending the examination and for the inspector to take on board. Yeah.
So if things are done properly, this was a policy, is it one you think would likely see the light of day at any local government inquiry, examination?
I think it's unlikely. And the reason I say that, just taking Lydia Park, we have the parish council that have been here objecting to any more pitches at Lydia Park. So if it went to a committee first for that to be considered, I'm pretty certain the committee wouldn't accept it in terms of Lydia Park. So those pictures will have to be found somewhere else.
And then go down further to paragraph 22. There are no opportunities available to the appellant for further pitches within Lydia Park. Proposed allocations within the emergency local plan part 2 site allocations development plan proposal would extend and intensify existing sites elsewhere in the borough. Just pause there. Have those allocations materialised and produced any additional sites?
Well, two that we dealt with, one was at Stone Yard. It was an allocated site in the local plan. The application was refused. We had to take it to appeal, and it was allowed on appeal.
So
And-
although it was allocated, they refused it. They refused
Yes,
the
they
planning
said it
commission.
was too dense and impacts on the neighbours, but it was an allocated site.
This council.
Yes, it's one of our documents that was Inspector Orr that dealt with that. So
Yes, Mr. Wood, just remind me of the reference number of that site so I
Yeah.
can track it down if I need to. I think they're all DS numbers, aren't they?
pardon, sir?
They're all DS numbers, these sites.
Yes, they are.
Just need to know which one it is.
I put it as appendix 6. I put it appendix 6 to Mr.
All right.
It's DS20, Inspector.
DS 20. Thanks, Mr.
You were just going through your explanation about this, was that you were referring to two examples and you were
so-
still telling us about the first one.
Yeah, that was land off Tongham Road, Badshot Lee. And that was where it was refused for the additional pitches and allowed on appeal. It's a family site. And the other case relates to sure where it is now. It was Kilnside Place, Badshot Lee. And that the permission for the additional pitches there was granted several months ago. The application had been in for 2 years. It was an allocated site. And I think the council is suggesting to extend it further.
Further than the allocation.
Further than the allocation, yes. Further than the allocation, or certainly further than the, I think the red line included additional land. The pitches stopped at a certain point before a paddock at the back because there was triple SSI that went beyond it, so it stopped there. But the councillor suggesting that more pitches can go in there. But bearing in mind, it
But is
took
that,
2 years.
is that beyond the existing local plan?
No. But bearing in mind, it took 2 years to get a planning permission for an allocated site.
What I was going to ask you, but I'll just deal with this first because it's important, is to what extent do you say that the part 1 and part 2 of the local plan, part 1 is 2018, part 2 is 2023, worked or failed?
Well, I think they just about got to the examination, the inspector's report in time before it would have been considered that the need assessment that had been undertaken was out of date. And then there was a subsequent change to policy, the PPTS in any event. But in terms of, I've just come up with 2 sites there, allocations, and the difficulty that we had of getting those sites forwards has sort of goes towards the failure box.
I'll come back to policy failure in a little while, Mr. Woods. But can we go back to paragraph 22 of this decision?
Yes,
And just that last line, this does not alter my concern about the numerical and spatial effect of a settled community. So I want to ask you about that. There's no examination, is there, of the consequences of the increase of numbers or the increase of land? It's the mere increase of numbers and land that she considers seems to trigger policy C. And I want to ask you whether or not you consider that to be the correct approach, bearing in mind the discussion we've had about the public sector equality duty and Article 14.
no, I don't believe so.
What approach do you say, what do you think of the sort of things that she should have been looking at? Apart from the fact that you say, well, she shouldn't have been looking at this anyway, because it wasn't a settled community.
Mm. Well, she should be looking at the needs of those persons involved and the difficulty they would have of finding alternative sites.
But let me put it a different way. If the evidence is, although the numbers have increased, there's been absolutely no other consequential effect on services, on access to education, on access to shops, on people getting the local bus, absolutely no effect. Would it still be appropriate, in your view, to dismiss the appeal on the basis of policy C?
No, I don't consider so.
It is the sort of one-dimensional approach that she takes there. Well, the numbers have gone up, the site's gone up, and therefore it's over domination. Logically, show over domination. Logically demonstrate over domination. Or does there have to be, in your view, something more?
Well, that was her view. It's a matter of opinion. But the council's view subsequent to that decision, subsequent to the refusal of the appeal applications, clearly must have been that actually more pitches can be provided at Lydia Park and it wouldn't be a problem in terms of over domination.
And just go back to this issue about equality of approach and Dunsfold. Now, as the crows flies, Dunsfold will be the nearest settled community because it will be a small town with every shop service that you could want in a few years' time.
Yes, as part of the proposals, there's shops, commercial buildings.
If that was taken to be the nearest settled community, is there any chance that the expansion of Lydia Park would over-dominate Dunsfold?
No.
Is that, in your view, a material consideration? Should the inspector just ignore it on the basis that it hasn't been built yet, or take the view, well, it's going to be built in a couple of years' time, and it's and what's going on here is going to pale into insignificance with the numbers suggest, because initially it's 1,800, and then it's going to go up by thousands.
It's my view that it'd be wrong to ignore that because of the fact that it's not just it's a planning permission and nothing's happened, although with the planning permission it's counted towards meeting their need for housing, council's need for housing, but it's the fact that there's been millions of pounds worth of investment in terms of the road infrastructure. You'll see it, the entrance to the site goes there, and the landscaping that's gone ahead before the houses are being built. So it's something that's going to happen, and in my opinion, shouldn't be ignored.
Is there anything else you want to say on reasons for refusal too?
No, it's not.
So can we go to your page 7 and reason for refusal 3?
you mean,
You're,
you mean 5, reason for refusal 3, don't you? PLA,
yes, it's
Yeah.
on your page, proof page 7.
that's appeal B. Same reason.
Oh,
I'm
okay, yeah,
just-
same reason. Doesn't matter, that's fine. We're looking at it wrong. Okay,
Yeah.
that's fine. You've already made a point before, and I'm sort of going to lead you here, that relates to development proposals relating to protected species.
Yes, it relates to, in the absence of specific protected species, yes, site-specific ecological surveys were undertaken. But the council was say that they don't go far enough.
And we've already gone to the issue of the baseline. I'm not going to take you there again. Just to remind you, your case on the baseline is that at the time that the surveys were done, what was on the ground represented the baseline.
Yes, I mean, that was because it was things that were done before the appellant purchased the site.
And your view is that that's the baseline the inspector should take, and therefore the surveys are an accurate representation of the
Yes.
Yeah,
position.
so we've done that
We
thoroughly.
have, sir, yeah.
Yes, can we move on?
Thank you, sir. I will move on. So what I want to ask you about is simply this. We know what we know what the PPDS says at paragraph 28. You could turn up paragraph 28. It's the second sentence about planning conditions, overcoming objections. Local planning authority should consider how they could overcome planning objections to particular proposals using planning conditions or planning obligations.
Yes.
In your view, Mr. Woods, is this a common sense case where any objections can be dealt with in that way?
Yes, it is. And that was the approach of the inspector relating to the Lawn Hill decision in Buckinghamshire. As one example.
Sorry, Mr. Woods, which decision?
Lawn Hill, sir.
Lawn Hill, thank you.
Yeah.
Sorry, Mr. Woods referred to that on the last occasion, which is why. Yeah. The objection has expanded a little bit because we've now got trees and we've got cutting of grass and things that don't relate to protected species. I wonder whether you'd like to comment on that.
Well, it's been demonstrated that that there may have been foraging ground available on the appeal sites, on appeals PLA. It's not been demonstrated that there was, but of course the council accepted on the Thatched House Farm decision where there was great crested newts actually there, that was acceptable to go forward. And it was in a known habitat area for the whitewood butterfly, whereas it's not known for the appeal site.
Now, in terms of conditions and site development and landscaping, are you proposing anything that would amount to planning gain and enhancement?
Well, as part of a site development scheme, you can include hedgerow planting, some wildflower planting along the borders to the hedgerow, and that would be of betterment for ecology and biodiversity.
I think there was a suggestion that some parts of the land could be isolated as for planting of appropriate vegetation that would assist the whitewood butterfly.
Yes, well, that will be some of the wildflower planting that you would undertake.
If,
And that will be subject to details submitted on a planning
if
commission.
this appeal is dismissed, could any of those improvements and betterments take place?
No,
Then turning to the final reason for objection, the absence of a site-specific flood risk assessment. Well, is that right? Well, were there in relation to the sites of flood risk assessment?
well, firstly, it wasn't a reason for refusal, but we've had a lot of discussion about flood risk and surface water. And
Sorry, it was a reason for refusal. It's reason for reason 4. That's why I've taken you that.
oh, sorry.
You
Yes.
well, that's why I interrupted, Mr. Woods.
Yeah, there was a flood risk assessment submitted.
Thank you. At that time, because what we forget is that this was prior to the maps that were revised. There wasn't the version of mapping that was relied upon by Mr. Smythe available, and the versions that were available UK version 4, I think it's called, were relied upon by Mr. Quick, and the other company whose name I've forgotten.
Under.
Thank you. So that no one can criticise, can they, that those reports were using the wrong mapping, because the mapping Mr. Smythe relied upon came about because he had available to him a later mapping than would have been available at the time that they did their reports.
Yes, that's right. And when they did their reports, the ditch was in place. And so
I
that
don't want
is,
to go through flood risk evidence again.
No, sir, I don't, sir, but I do want, this is an important, I don't want you to spend loads of time going through flood risks, Mr. Woods. But sir, there is a
We've
reason.
spent an awful lot of time on flood risk.
I wasn't going to go there again, sir, to any great extent. There is a reason for this. Just bear with me for a minute and I'll move on very quickly. Mr. Woods, could you carry on with the inspector's permission?
I was just saying that the flood risk assessments were undertaken. It was pointing out that on the plan it showed a ditch on both of them. So when they did their flood risk assessments, the ditch was there and there wasn't a problem. It was in flood zone 1 and it was fine.
Okay, Mr. Woods, I'm going to lead so that we don't go over other issues in my learned friend objects. Your proposal is that what's happened here is the ditches have been filled in and they need, and the ditches need to be unfilled.
Yes, in essence, yeah.
Is it your case that the changes observed by Mr. Smythe come about because of the filling in of the ditches? And that's the cause of the surface water flooding that he's proposed occurs.
Yes, it is.
Is it your case that this can be dealt with by a condition relating to reinstatement of the ditch and any modelling that might be required in order to be able to be certain the ditch goes back in the right place?
Yes, it can.
The reason I wanted to go here is I didn't want to go back to the things, but to ask you the question that I asked Mr. Ward in relation to this, which was this could just be a simple condition the inspector could impose and grant for temporary planning permission. If it were a temporary planning permission to allow these investigations to take place, if the inspector came to the conclusions that that was the appropriate approach, what sort of time period are you suggesting that temporary planning permission should be for and why?
I think the relevant period will be 3 years. And I say that because that would allow ample time for the matters to be submitted relating to modelling and reinstatement of the ditch or proposing reinstatement of the ditch.
Could you just
and
keep
going
your
through-
voice up, Mr. Woods?
Mr Masters, I'll have to check my notes, but I think Mr Woods has already been asked this question earlier in the inquiry. And I think he may have given a longer period of time as his answer. I'll have to check that.
Could you, sir? I didn't think he had.
Well, strangely so, we've had this discussion outside of the inquiry, and I said 3 years when asked a question.
I'm
but-
sure you've been asked the question before. It may have been by Mr Cottle. I don't know. I'm sure. I'm certain. I don't know.
I don't know if you can help us, Stephen. Sorry, I thought you were looking, don't worry.
Well, Mr Masters has just asked Mr Woods his view on the length of, and I think you've already asked it.
I'm pretty sure that I was linking it into the plan period because we didn't know how long it
Yes,
would
but I don't
take.
think you put that in the question. I think you just asked in the what the length would be.
I can't remember now.
I'm
It's a
sure you
Friday
raised it.
afternoon. I'd have to go back through my notes. Sorry.
Yeah,
So can I leave that to you to check your notes and
I will check my notes. Yes.
but I will in the context.
I mean, irrespective of the reason for the question,
Yeah.
there's no need to ask the same question again. That's the point.
No, well, I wouldn't, if I'd have realised it had already been answered, but I did it in the context, a very specific context,
Oh, I know. Yeah.
which was only if you came to the conclusion that a permanent permission couldn't be granted. In relation to the surface water flooding issue, what would be an appropriate period to allow for a temporary consent for modelling to be done? I'm not sure, so the way that I put it was the way that it's been put before. I think a more generalised view was put before.
Yeah, I think if it was to do with the local plan preparation, then it will be 5 years. If it was linked into that, but I've specifically addressed my mind to the concerns about surface water drainage and resolving that in a quicker way. So that's the reason I've said that is.
But
in
so
local plan period,
with the
'cause-
caveat that I asked Mr. Woods, only if you came to the conclusion that the surface water drainage couldn't be met by a full permission on the basis of the condition itself. In other words, spell it out. If you felt that the modelling was a real prerequisite. Mr. Woods is, so if there is, so Mr. Woods, if your answer before was 5 years in relation to a planning and temporary consent, I think you just explained to me, Inspector, why it would be 3 years in the context I've just put to you. But just for clarity, could you say that again?
Yes, if it was specifically because of concerns relating to surface water drainage, then I think the 3-year period will be appropriate to have the modelling done, propose it as part of the condition, have the works carried out, and then you have that trial period to demonstrate that actually it's not a problem anymore related to surface water. But if you take the view that actually it's an obvious conclusion that reinstating the ditch will get it back to where it was before and it won't be a problem, but for other reasons that there might be better sites coming forward once the plan is prepared than a 5-year period.
Mr. Woods, and you might know so, but I'm following the same process of issues that I went with Mr. Ward. So I'm now going to take you to policy AHN4, which you address at paragraph 23 and 24.
'23 and '24.
So this is in I'm in your proof of evidence relating to the POA, actually.
I go by paragraphs, which you are going by, but it's
This is it.
section 1, then section 2. Well, that's page 24.
Yeah, page.
It's a paragraph, sorry.
Sorry, no, I probably did. I'm always doing that. policy context. Are we on the same page, as they say? Good, okay. No, I can do this a little bit quicker than I did it with Mr. Ward, because we looked at the things that he agreed. So I don't think there's any issue about safe and convenient vehicle and pedestrian access to the site.
No,
2, there is a safe and easy and safe access to a strategic network. Well, I'll just pause there, because I think Mr. Ward, to be fair to him, made the caveat about flooding and access relating to flooding, and we know that flooding is an issue, and there's an issue relating to outside access, but just so we
Yeah,
pause.
that's criterion 1, I think he made the caveat.
Yes, he
Yeah.
did, sir. That's why I just went
Yeah.
correct, so it wouldn't be fair not to have done that. Just looking at the 2 sites, and I'll take this as the 2 sites if Mr. Cottle is happy for me to do so. Okay. In relation to site B, is most of the occupied area of the site outside the service water flood area?
yes, it is, yeah.
So is there any issue about safety of those people on that site?
No,
There would be an issue about them leaving the site at a time when there was service water flooding and the access. But is there any definitive evidence as to the extent that any flooding would in any way be a danger for them or a danger for others?
no, and the longevity of any surface water is fairly short.
Well, that's the other point I was going to ask you. Is there any evidence on depth, velocity, or the time period for which it will take place?
There was some reference to depth. That doesn't, not time period.
Okay, turning to site A, and we can see from the maps produced by Mr. Smythe, and if you remember, in relation to the mapping I produced by Mr. Smythe, we compared that to the mapping produced by Mr. Quigg, which is based on 2023 LiDAR,
Yes.
which didn't have an extent of flooding going up to the site. And Mr. Smythe's evidence was that his LiDAR was based on 1999 and did go there.
2019.
29. And I wondered if you could comment about whether that could be accurate or not, bearing in mind.
Well, no, it's not the up-to-date situation at that point in time.
The inspector has asked us to investigate that, and we'll be doing that and coming back to him. So I don't need to take that any further. We know the topography of this site. We know Stovolds Hill is a hill, but water runs down. So in terms of service water depths on site, what do you say the inspector can conclude in relation?
Mr. Masters, these are questions about flood risk, which we've been through at length.
Okay, so
I think you can,
Yeah.
I'm happy for you to pick up on the points that your witness has reached and put those in terms of the policy implications, but I don't want a rehearsal of the flood risk questions and answers.
no, so I was really it was just in relation to the time period, but I take the point, and I am straying, and I understand that, so I'll stop. Let me go on then to the criteria, back to the criteria, and not get sidetracked. So criteria two, I think there's no dispute. There is an easy and safe access to a strategic node road network. The site does not generate traffic in the amount that's accepted. 3, the site is able to accommodate on-site facilities for parking and manoeuvring of vehicles and storage, play and residential amenity space accepted. 4, the site is located within a reasonable distance of local families and services. No issue of local sustainability has been taken. 5, the site does not have an unacceptable impact on physical and visual character. Now in relation to that, Mr. Ward accepted that was the main issue in which the policy was in dispute. And
Yes.
that's the character issue that the inspector will have to look at.
Yes, indeed.
Now, I don't want to go back over character and appearance again, but I just want to ask you this. If the inspector accepts eventually that of the term there is unacceptable impact, but it's not an unacceptable impact, would that, in your view, mean, and I can take you to the rest of the policy quickly, that we would comply with policy HN4?
If it's not an unacceptable impact, yes.
And I want to ask you about unacceptable impact in the context of what we know about the council's own proposals for expanding other sites. Because they would have to pass this policy, didn't we? So all the other sites to be expanded in Stovolds would have to also not be an unacceptable impact on the physical and visual character of the area.
Yes, that's correct.
We know that the sites further to the south actually go up the hill.
Yes.
So in terms of prominence and visuality, would that make them more prominent or less prominent?
I would imagine, really, when you're looking from a distance, to make them more prominent.
So if the council find that they don't create an unacceptable impact, sites lower down will be less easy to see. What impact, will they be a greater or a lesser impact?
But they will have an impact. I would say a lesser impact, but you would see them against the backcloth of the wider area of caravans.
Mr Woods, not entirely clear in your answer. So which sites are you saying would have a lesser impact? The appeal sites or the ones that are on the south side of Crocus Lane surrounded by other development?
The lesser impact with the appeal site, because the on the south side is on higher land, so that's what you'd focus your eye in on that there.
Oh, in terms of
Looking from Hascombe Hill, it is.
Yeah.
If you're looking from the road, which is a field beyond the appeal site, well, A and B really.
Yes.
You'll look through a hedgerow, and so you really won't see very much of the appeal site. Once the hedgerow is there, you'll have a double hedgerow.
Mr Woods, I was thinking of it in terms, and I think you've answered the question, but I'll put it to you again, in terms of the impact on the national setting of a national landscape, if there is any, which would have a greater impact, the ones that were visually more prominent because they're higher up, or the lower down ones which wouldn't see so much of.
Well, that's what I said, the ones that were higher up.
Thank you. I'll just read out the rest of the criteria. The site is capable of being provided with essential services. No issues been taken with that. And then the last one, it accords with the other policies of the plan. Well, the inspector has.
Yeah, I think the council, I think I've glimpsed an email that came over from Mr Bennett about services. I think there's going to be another suggested condition about foul drainage and that sort of thing, which is fair enough.
Okay. So no issue. But then that you have a whole section on unmet need, starting from your page 28. I'm not going to take you there because we've dealt with that and we're going to come back to that. And then it from page 42 onwards, you deal with your case on the main issues, but I've taken you there anyway, so I'm not going to ask you questions about that, if that's okay. So what I'd like to do now is just ask you about one or two other issues that have arisen. First of all, the position in relation to unauthorized development.
Okay.
We know what the 2015 ministerial statement says. There's a question I'd like to put to you. That ministerial statement envisaged that it would be reviewed within 6 months. Has it ever been reviewed?
Well, not until recently. In the consultation draft of the framework, it mentions it there, but up until then it hadn't been reviewed. And the point is there's been several iterations of the framework where it wasn't included within that.
Do we give any weight to the consultation draft of the framework? Because we don't know, there's no guarantee anything will be done in relation to it.
I would say limited weight.
Secondly, so that we understand the position, I wonder if you could go back to that 2015 written ministerial statement, because unauthorised development was only a small part of it. If you remember, it was a policy for calling in greenbelt sites that was proposed by Mr. Pickles. And that part of the written ministerial statement was declared unlawful by the High Court, by the Court of Appeal, in fact.
Yes, that's right.
So it's rather unfortunate that everyone's relying on a document that in part has been declared unlawful because of a policy point. And has there actually ever been a policy document that has been consulted upon in relation to unauthorised development?
A national policy.
Yeah.
Well, the framework has been consulted on, the consultation draft of the
Well, forget that,
framework.
because we give limited weight to that at the moment and we don't know where that's going. Prior to
Not prior to that, no.
So what weight do you say the inspector should give to the 2015 written ministerial statement that's now 11 years old and that hasn't seen the light of day in any policy context?
Limited weight for two reasons. One, for the reasons you just said, in terms of review, it's going to be done very quickly and wasn't. And secondly, what the appellants have done on sites A and B, I don't know about C and D, but on sites A and B, it was, the hard standing was pre-existing, so it's anything that came after that.
Thank you. And then if we could go to your page 58, we then go to material considerations that are in favour. Sorry, page 58, sir. So I said to be an hour and a half. Hopefully I'm going to stick to that, but do I have about 15 more minutes? 10, okay. I might be 15. I'm doing my best. So, but it won't be much longer than that. So, Mr. Woods, paragraph 26 is previously developed land mostly. Does that really apply? It's not previously developed land, is it? Untidy and
No.
derelict?
Yeah, it probably doesn't apply now.
Okay, thank you. General need for pitches, well, we know that, but I'm not going to go over that again. I just want to ask you about 5-year supply and the test, because that's rather important in this case. So the test, if the inspector finds that there's no 5-year supply, then we look at the test, don't we?
Yes.
We look at the test in 11D in the framework. Now, Mr. Ward's arguments to that, well, you don't go to the test for two reasons. One, because it's flooding, which I don't think he went to, but I'm going to, because it is part of the test in 11D. If you look at 11D, you'll see that footnote 7 refers to flooding as well as it refers to national landscape. Are you with me? Have I lost you?
Yeah, I'm just waiting for a question, yeah.
Yeah,
I'm waiting for the questions.
sorry, sir, I thought so, Okay, the question uh, is therefore, is this a case where you consider that footnote 7 in relation to a site that's not in the national landscape applies?
There's 2 points in the footnote really relating to flooding and the other relating to national landscape. It's not in the national landscape, and relating to flooding, we have differing views on that. We say that actually there's not a problem, so therefore 11D would apply with the tilted balance.
Okay, so if the tilted balance applies and the inspector finds there's no flooding issue, or it can be dealt with by condition, the test there is significantly demonstrably outweigh the benefits. Now, I don't think anybody has challenged the benefits here because the benefits are substantial, bearing in mind the need. The inspector would have got to the fact that there is an unmet need. So the benefits would be substantial.
Yes.
Therefore, does he address other harms in terms of whether they significantly demonstrably outweigh the benefits?
No, I accept that there will be harm, but not substantial and demonstrably to outweigh the benefits, no.
So in that context, I just want to go back to something Mr. Ward said, and I discussed with him at a little length when we looked at the benefit of the best interests of children, for instance, which applies
Yes.
here. And we know, and I'm going to lead again, that there are significant medical and welfare issues involving the families on these sites. I'm not going to spell them out because we know what they are.
Yes.
We've learnt about Matthew's child and those difficulties as well, which have been new. What Mr. Ward said is, well, none of that will significantly and demonstrably outweigh the harm here to flooding. What do you say to that?
No, I disagree. And I'll put it, what will be worse is to have some surface water flooding on occasions, or to be in a lay-by and opening the door of a lay-by and a lorry thundering past, and the danger to the children that occur in such locations, a roadside existence would be seriously harmful in terms of danger, and also those children would not be able to access proper schooling, and it will be difficult in terms of appointments for hospitals, etc.
You may remember the exchange with Mr. Ward on this, because initially he said, "Oh, will that comment only related to the fact that I was of the view that alternative accommodation could be provided in Stovolds," is what he said, on these sites that were being proposed.
Yeah, well,
let me just pause for the question. Sorry, no, carry on. I'll answer that if you want to.
yes, I heard that, but I understand that yesterday, in terms of personal circumstances, Mr. Simon Doherty, here now, was asked what impact that would have, and I think Mr. Cottle has already been through that point. It would, if he's not at the site, there's nothing available to rent or buy at Lydia Park, so that's that point. And secondly, if he moved away from where he is at the moment, he would put his son at serious risk if there was an emergency.
Then I put to Mr. Ward, okay, if that's your position, then do you accept that if it was then moving to the road, then there would be significant demonstrable harm that would outweigh the benefits? And then his reply was, "Oh no, I'm still of the same opinion." And I just wanted you to comment on that.
I don't understand that approach at all, and that's I think he should have said that carried substantial, very significant weight in favour of the appeal proposals, and he didn't do that, which was surprising.
Now, does that issue, but the thought of kicking all these families out to the roadside, balanced against the any harm by surface water flooding? And I want to come back to that harm because this is a question I mean, Inspector slightly stopped me asking last time. In relation to Tom and his site, where we see that the flooding extends, the flooding footprint of surface water flooding extends over, is there any evidence that that's going to cause a danger, bearing in mind he's on a hill, a danger to him and to his family on site?
No, I haven't seen any such evidence.
And why, in your opinion, would surface water not be a danger? Would the surface water cluster and stay on his site?
No, it would run away from his site
Why?
because of the slope of the land.
And so, in your view, in relation to him, we know about the welfare circumstances there, the health needs of himself, his father, and his brother. Do the benefits of them staying there significantly, demonstrably outweigh the harm?
It does significantly and demonstrably outweigh the harm. Yes, definitely.
And if the inspector had to look at this question twice, once in terms of a permanent consent and once in terms of a temporary consent, would the harm be less if it was for a temporary 3-year period than it would be permanently?
Yes, it would. Yeah.
So I have no further questions. I think I kept to my hour and a half.
You did, Mr. Masters. Thank you for doing that.
I'd like to be a lot shorter if I may. Just a few
I
questions.
didn't think you were going to go today, were you?
Well, you can only, I only want you to go today, Mr. Cottle, if you can do it in 15 minutes. If not, I mean, you'd suggested half an hour. And I've got to finish at 5.
Yeah.
I
I
would
don't
like
I don't want to short ground that you've got to cover on behalf of your client. It's important that you do that. And if you're only doing if it's as short as half an hour, would it not be more sensible to include it with the cross-examination?
I just wanted to go back to a couple of points, but I'll leave it until Tuesday.
Yeah, good. Thank you.
So is it going to be Tuesday?
Well, that's what I'm. I mean, we do need a discussion about that. So we've got 2 days next week, Tuesday and Wednesday. I've already said I don't really want to alter Tuesday morning because there are parties here who I don't want to alter their arrangements that they will have made. My best estimate at the moment is that we need, I'm assuming, about an hour and a half on this session with Mr. Woods. Sorry, 2 hours altogether. With Mr. Lintott and Mr. Cottle. And it's a question of whether that sits more happily with Tuesday afternoon or Wednesday morning. I think the site visit could take some time, and I want to make sure I've got sufficient time for that. I'm thinking conditions round table, maybe an hour and a half on that. My inclination at the moment is to continue this session Tuesday morning, and because I've got Wednesday morning, because I want to make sure I've got sufficient time on to do the site visits. If I do those on Wednesday morning, a time will have been given for the closing submissions, which other people might come to, and I don't want to shorten unnecessarily what I'm going to be seeing on site.
I mean,
That's my thought.
the difficult, I mean, my approach generally is to fit in with whatever is most convenient for you, but that would
Yes.
mean that we're having Mr. Wood's remainder of the evidence immediately before we then
Closings.
close.
That's true.
afterwards, which
Yeah.
is going to
Yeah.
be extremely difficult. I mean, unless we do.
No, that's
closings in
that's a
writing.
good point, and that's one of the reasons why I
I
always try
find
to do
it
site.
impossible really to do that.
Yeah.
We've done very well in terms, we finish it.
No, I think Mr. Lintott and Mr. Cottle have got a good point in terms of, I want all advocates to have proper time to prepare closings and to take account of what's been said by it. I know you are, yes, but I'd like to keep the option open of them being delivered in person at the moment. Let's pull conditions forward to Tuesday afternoon and with this session and move the site visits to Wednesday morning. Yeah,
There could be a suggestion that Pollingford Place is a proper place for an allocated site. And that was an appeal my learned friend and I were on. And the planning authority were very concerned about the impact of the national landscape on that site. And the inspector was considering the juxtaposition of the acceptability test and RE1 and RE3. And you might find that helpful in the way he dealt with that. But the proximity of the national landscape with a pronounced hill exactly behind the site. And it seems to me that the current local authorities' position is that the harm to the national landscape won't be an issue there, but it is here. And it's just another contradiction that you could weigh by actually seeing the Pollingford Place site and walking up the path behind it on the national park and looking right down on top of the site.
Not sure we've got the Pollingford Place. It's not in evidence, is it, on this appeal? Whereabouts do you have that in mind?
We've got the decision letter in the evidence before this inquiry.
and what's the name of the site again, Mr.
It's where the extra need came from on the Ellen's Green, where my learned friend and I were dealing with the case, and they'd undercounted the need by 2, and it was added in extra by Mr. Jarman. We were arguing.
Yeah, and the location of the site is
Pollingford Place, Ellen's Green. It's in Waverley. It's very close. Well, I'll
I think that's a good idea. Can I go back to say, when are we going to do woods? We shifted the position of round table.
Yes. Yeah, Mr. Woods on that would be a Tuesday afternoon. Yeah. Mr. Woods.
Can I just say, obviously I won't speak anything about what I'm talking there, but it could put me in some difficulty if we're doing the need on Tuesday morning and I can't speak to anyone about it
If you could,
because of Purdah.
well, I think we had this discussion in connection with Mr. Smythe, who was in Purdah for a very long period of time, and it was agreed that the Purdah would be limited just to the area that it was given.
Just wanted to
evidence.
clarify that, so
Yes.
that's all.
Yeah.
Thank you.
So
That's
I
right.
don't see why the similar arrangement can't
also
apply to you.
I'd need to speak to Mr. Woods about the further information that you requested yesterday, the schedules.
Yes.
Yeah, I mean, Inspector, as you say, where Mr. Wood's evidence has been split into various categories, my reading of it is that it would only be the category that he is giving evidence on that he would
Yes.
be incurred on.
Yeah.
But in terms of Pollingford Place, I mean, I myself it's not been referred to or related to this section of the evidence
Yeah,
That's all.
I can't recall it being mentioned. I may be mistaken, but
I'll introduce the topic again if I need to early next week.
right, okay. I don't want to include it at the moment. Will then. Right, I want to make sure that we've got sufficient time on Tuesday to cover all the ground. So I'm going to suggest a 9:30 start again.
They all said, when you get here on time, they're all about
Yeah, and in terms of the order of proceedings on Tuesday afternoon, I would want to deal with Mr. Woods first before we move on to the conditions. And I think the only other thing on conditions is that I know the councillor said they're looking at it. I presume the same goes for the appellants as well. So I'm hopeful of getting an updated schedule, including, for example, the document that was put in earlier this week for me to see on Monday.
Can I just make a sort of pessimistic comment, which is that I'm very concerned on the further round table because there are so many issues in the pitch delivery assessment. We're going to be very hard pressed to complete that within the time available, I feel.
Oh,
It's a matter for you, Inspector. You've got,
Yeah.
you've got conduct of the round table and you can just concentrate on what issues you want to concentrate on.
the reason for the round table, Ms. Scotland, is essentially by way of update. I appreciate this substantial documentation. It doesn't mean that it all has to be gone through. What I'm looking to the main parties to do is simply update their cases. Where relevant, it's not an invitation to spend all morning because we have all morning available for it. I want parties simply to focus on the main points that have changed since we last had that discussion last year.
So
Okay. Ms. Cutler, was there anything else that you wanted to raise?
no, sir, thank you.
Mr. Masters? No. In that case, we're adjourned until 9:30 on Tuesday morning.
Thank you very
Thank you.
much, Inspector.
Mr. Bennett, you said I could keep my boxes here over the weekend. Should I just put them in the mayor's parlour? And will they stay in there? I'll just put a lid on them then. But if I put them on the side on the round table. Okay, thank you very much. Of course, yes, yeah.